Hello, hello, hello. It's Attorney Mike Grabban coming to you from Chicago, as usual. The weather's not like that. But here we are, day 4 of this debacle. Let's see how it goes. Let's see what's happening with the stream here. No, I need that. Well, that was quite a new. Right into the wall. Right into the wall we go. That's okay. That's okay. Because I got a fresh one for you. Oh, we've got court. No, we've got a new wall.
I'm sorry, Judge, would you answer a question for me then? Did you just say that I chose not to be in the courtroom in person and then are saying that it's not my choice after you said that? I would like you to know that you're fired, ma'am. You just lost your job.
That's one of my favorite new videos, where a pro se defendant fires the judge because, well, he's a genius. Just ask him. Oh.
Absent, and be brought to my attention before we proceed.
Yes, Judge. Good afternoon, Joe Kimok on behalf of Mr. Boatwright. Two things. There are two sets of photographs that I'm seeking to introduce through this witness. I've showed them to both of these counsels, and I showed them to the state. The state is objecting to one of them, and so I'd like to hash that out if we could at this time.
Okay.
May I approach?
Yes.
The basis of the objection, Judge, as you're looking at them, do you want to show them the other set as well, for the record?
Sure.
I'm agreeing to the first set, not the ones in your hands, Judge, but I'm agreeing to the first set. Ordinarily, and I told Mr. Kimott this, I'm still in my case in chief. I'm not aware that defense can just enter evidence on my side of the case unless by agreement. The first set, I am willing and agreeing that can be entered because it came from evidence that I'm going to enter anyway in my case in chief, which is Michael Boatwright's phone. So that's why I don't have an issue as to that. The second set is not, and it's not necessarily something that I was going to enter. I believe it comes from either Facebook or Instagram page of the witness. And I explained that to Mr. Kimaka. I may not even enter that. So I'm not agreeing to the second set. I don't know if Your Honor has a preliminary ruling on that, but I'd also argue that it's not relevant at this juncture, the images in the second set. So I'm objecting to it.
All right, well, let me address it in a couple of ways first.
I love it when opposing counsel tries to enter the same evidence as me.
Traditionally,
We call agreement.
state enters evidence on the state side of the case, defense enters evidence on the defense side of the case. However, it is sometimes my practice pursuant to 9612 to allow counsel from the other side, depending on whose case it's on, to go ahead and enter evidence through a witness that's now testifying. This doesn't matter, again, in the same rationale that we're trying three defendants together, a matter of judicial economy.
Thank you, John.
Witness is here, it's on the stand now.
You don't know how to pronounce the judge's name? Is it Yuzan? Or Yuzhan?
Identifying an item to come into evidence just seems to be a waste of judicial resources, and therefore will allow defendants to seek to introduce evidence on the state side of the case if, you know, the witness is already there. So if that's the objection, it's overruled on that point. Now,
He is kind of low-key fun.
relevancy and other things are other objections. So are you making an objection along those lines as well?
Yes, Your Honor.
Okay,
The second set.
understood.
I had some good expressive face shots from him in my Discord today.
I don't want,
I
the witness is on the stand at this point.
Okay. Come on.
Oh, you got to be kidding me. Are we just waiting for the witnesses? Is that what's going on? Because then I can play this.
And there was, and I hate, God, I hate this. They said a bunch of dick pussy, dick pussy, dick pussy, dick pussy, going back and forth between texts with one another, and I never want to hear it again.
By the way, while we have a moment, a little program note. I wanted to squeeze in a happy hour. I've got a good clip. It should be fun. So I set it for 4:30, assuming this thing closes down around 4. And I'm using this clip on it, but why not? This is another fantastic one. That one's called Mel Karen in Court. I just did the video. I highly recommend it. I really do. You know, it's just the clip was that good.
I would like you to understand that I know what false identities are, and sometimes famous people need them. Marshall Bruce Mathers, Eminem, at one point studied law and passed the bar exam to become a lawyer. If he still is a lawyer, I want you to get a hold of him for me so that I can communicate with him.
That guy wants Eminem to represent him, and he will accept no substitute. He indicates he doesn't have any money to hire an attorney during the hearing as well. So, I mean, first, let's start with some basics here. Eminem, as far as I know, is not an attorney. I mean, maybe he is, but he hasn't mentioned it, you know, as far as I know. And let's say he was an attorney. I think he'd be pretty expensive. And I'm not sure he's licensed in Wisconsin or anywhere else for that matter. I believe that case is out of Wisconsin. What are we doing here? That's not a good sign. We're getting rid of the witness. Oh, good Lord.
Or not to be huddled, yeah, not to be.
We're gonna squabble about something else. Okay.
Judge, the photographs that we're seeking to introduce all come from Mr. Allen's Facebook account. They're all pursuant to the records posted by Mr. Allen. All of them contain Mr. Allen in the photographs with other men who match the description generally of the two men that we can see in the surveillance video at Riva. The last one in particular is a photograph of 4 men together that was taken less than a month before the shooting. And none of, obviously, neither Mr. Boatwright nor Mr.
It's damning, but you're not keeping it out.
Those photographs. That 4th photograph
Nice try.
contains both Mr. Allen and Mr. Williams, along with 2 other individuals. It is part of our theory of defense that Mr. Allen is not only testifying to protect himself, but to protect the other 2 actual
So what we have here,
culprits, the actual murderers in the case. And so we are seeking to introduce these photographs to show the jury that not only were there other men in Mr. Allen's life who matched this description, but that who he was friendly with, that he hung out with, and that he hung out with Mr. Williams shortly prior, just prior to the homicide.
basis of this
presents
objection
another
is
problem.
They
The
all
other
look
problem that
alike.
it presents is now, if they're seeking to introduce photos, which is a portion of a complete set of social media, it's the same issue that Mr. Kimmock was addressing yesterday in terms of the rule of completeness. Also, in the second set of photographs, there are what the state would argue gang symbols that are being thrown up by one or more of the individuals, which then introduces potentially an issue that the state would have to rebut, which goes against, I believe, the 3 co-defendants. And it's more than just saying that these photographs, because for convenience, this particular witness can authenticate them. This witness is available, and will be available throughout the duration of the trial.
I've already ruled on the order.
What I was going to say is, because of the fact that this witness is available, the other issue is the authentication regarding where the photos come from, specifically Facebook. That is a separate authentication issue regarding the Facebook account. Same like the state would have to authenticate the Facebook through whether an affidavit or a records custodian. I believe this is an attempt to backdoor that in and to get in only a portion of evidence that might be favorable, I guess, to their defense. If that's their defense and they intend on making that their defense, they should put on a case if they're going to do that. So they're attempting to do that through the state's case, which that's the reason why I'm objecting as to that. And the other evidence I'm putting in anyway, so.
Judge, we would join in the request Mr. Kimmock to have this admitted at this time. We feel it's directly relevant. And the witness himself can, of course, talk about authentication and give us everything we need. We don't need anyone from Facebook.
Correct. As to the authentication, this is the best person to do it. It's his Facebook account. He's the one who posted the pictures. He's the one who's actually in the pictures. As to the best evidence, all of the documents rule, I am more than happy to provide the entire report from Facebook. There is an extraordinary amount of
watch the judge's
prejudicial
face. It's fantastic.
information about Mr. Allen that there's no possible way I could get that in. It has nothing to do with the homicide. And so if the state wants to do that, we're happy to do that, but there's just, it's his private Facebook account with all the messages and everything like that. It's just these photographs are relevant. They can be authenticated by this witness. We have to be able to do so.
First of all, again, I've already made a ruling that I'm going to allow the introduction of evidence on the state side of the case. Yes, it's over the state's objection. Secondly, with respect to authentication of the photographs, the witness appears in each of the photographs, and similar to my ruling on evidence that the state was putting in, he certainly, don't have to know who took them, don't have to know that they come from Facebook, don't have to know anything else. It's just a photograph, and he can either identify them as being fair and accurate representations of what is depicted in the scene, or it's not. So I don't have a difficulty with that. With respect to whether or not there are gang signs being flashed, we are not going to have anyone come in and testify about what are or aren't gang signs. And I suppose there are members of gangs who, if they saw signs, would recognize them as signs. Just as a person in the world, the court is aware that kids, adults, people who are not members of any groups or associations oftentimes make funny symbols with their hands, sometimes they make symbols that are gang symbols, but that doesn't necessarily mean that they are members. So, unless council is intending to introduce them and say, so I see people are making hand gestures, what does that mean? That would be something different, okay? If it's a matter of, is this you, and do you know any of these people? I think that's fine. I would also say, though, that we are bordering the area of relevancy if we're trying to bring out how many people in Mr. Allen's life might be thin and between 6 foot and 6'2". That could be thousands of people. And I'm not going to allow the defense to bring in photos of thousands of people who may be of similar height and build, because I think that stretches the level of relevancy.
Yes, Judge.
But are there any other objections to these?
No, Your Honor.
Okay. Then over objection, if they can be authenticated, I will allow them in.
And Judge, we were just handed some photos by Mr. Padilla, so we should take a look at them before we address
Sure.
any potential objections.
Okay, that being no,
I'm funny. That's really good.
Hey, Biggin. I think Biggin's going at 3:30. I'm going to redirect this stream there, but I think this one's going to end at 4.
And, you know, it's not the system itself, because I can turn the system off.
That makes it.
I can turn it on.
Okay, that's why.
And I can, no what? No, no, some of the buttons.
I wanted to look at it.
I wanted to see it working, because I can't, it's not like the whole screen is frozen, I can't hear anything. The unit? No.
Ben is going, I believe, at 5:30. I'm talking Central Time here. Just accordingly.
Yeah, she needs to circle, unless you're gonna do it as a, are there 3 pictures? I don't know. Maybe let's composite once it, everything is on the, so, yeah.
No, it should come up.
So they don't get it weird. But it's green.
I think we need this
And
one more
and I hate this. Ain't nothing but some dick pussy, dick pussy, dick pussy, dick pussy, going back and forth between texts with one another, and I never want to hear it again.
I did unplug it and plug it back in, so it's rebooting.
It's rebooted.
Your Honor, are we back on the record?
If you'd like to.
I'd like to be. There's just some additional photos that if we can address while we're, on behalf of Mr. Williams.
Oh, sweet Jesus. Put the witness on the stand. This is day 3 of this guy.
So there's 3 photos total, and they're close-ups of Mr. Allen. I recall the circumstances that Mr. Padilla took them under.
Oh, for the love of God.
And when he was deposing Mr. Allen, the questions about them were also regarding the gang affiliation of the specific images of the tattoos. I've asked Mr. Padilla about that. He says that's not the reason that he's going to be entering them. I would object if that is the reason, or if the line of questioning even comes close to that. He indicated that he's going to be asking for a completely different reason, and so I wanted to put that on the record in case it becomes an issue at a later time.
Judge, again, I will not be getting into gang affiliations.
So what is the purpose?
The purpose is, I'm gonna put him on the stand, and he's probably gonna say he's remorseful, and bottom line is that he continues to break the rules. I have the image of him when he got arrested, and I have those images. That's one of the main reasons, and there's other reasons. Would you like for me to continue?
Yeah.
Okay, there's also the fact that he has a tattoo of a bag of money tattooed on his face, and in this case, he was charged with a homicide where they took a bag of money. So I believe it's relevant to say to a jury, he's remorseful. If he tells me, I've been remorseful since this happened, really? Because when you go to Broward jail, you continuously get tattoos and things that could be construed as you're not remorseful and you keep breaking the law. Or the rules. I believe that it's relevant.
Regarding remorse, that's not, I mean, his feelings on what he did after the homicide or how he feels about it are actually not relevant. I didn't elicit any testimony regarding that. Also, anything that he's doing, breaking the rules of Broward County policy and procedure while he's in custody are considered prior bad acts, which I don't know that, the way that he wants to bring it out, I think we would have had to have a prior hearing regarding that to show some relevancy as to the crime at issue.
Press argument was
And
the first
so
one.
I'm not sure I would object based on that. And the jury can see, I mean, he's been here, this is gonna be his third day close to them in custody. He's not dressed up any different. They know he's in custody. They know he's pled guilty to murder, so.
Judge, I believe that depends on how he testifies. And I believe that it is relevant and I should be allowed to do that.
All right.
Beyond the scope, shut it down. Bring on Fat Boy Slim.
I just don't follow the argument that a tattoo of a bag of money means the person's not remorseful. I think that's a stretch.
It sure is.
Secondly, the idea that he's breaking some infractions with respect to adding additional tattoos while in custody is such a collateral matter that would need testimony of people talking about what the rules and regulations are there and what exceptions there are, and they just puts us on a collateral issue that is not particularly relevant to the case. It would lead to mislead the jury and confuse the issues. And so if those are your reasons, your request to enter these are denied. Noted and preserved. If you would like, we can make those a court exhibit to attach for the appellate record.
Can I keep brainstorming and maybe address it later? Here's my final thing. At some point, I'm requesting permission to proffer a cross-examination of Mr. Allen about the alleged statements made by Mr. Newsome yesterday. That would include exactly where he was and all of that the court has said that we should not get into. And so at some point today, whether it's before or after, I'm requesting permission to do that.
This is outside the presence of the jury?
Yes.
Okay.
The court has ruled that we can't ask him any questions about it being in custody. And
Well,
circumstances.
He's
that
in
happen.
custody, but we're in custody. So
Right. I mean, that's part of our obvious theme of our cross-examination is that he is lying, is that he is continuing to lie. I think there's very serious holes
Yeah, we've heard
about what Mr. Newsome has said. And I'd like to be able to cross-examine him on that. The court has said no. I would like to proffer that.
okay, you can proffer that, but also understand the rules of evidence when we're talking about, again, collateral matters. You are generally stuck with the answer you get. Correct?
Yes, Judge.
All right. Would his having been spoken to for whatever reason by a defendant you are not representing be a collateral matter to you?
No, No, because Mr. Boatwright is sitting at the table with Mr. Newsom. This jury has been led to believe that it happened in the courtroom, and which would also tend to suggest there were other witnesses to it.
Which would be collateral evidence, which the court would not allow you to come in and bring extrinsic
It
evidence.
is collateral
of
evidence.
Collateral matters to the trial.
I mean,
Just
with the
get the witness on the stand and continue.
I don't believe that there's any rule that would prohibit us from cross-examining him on something that he has lied about on the stand. And it is our position and belief that he was lying on the stand in a case in which Mr. Boatwright is a defendant.
Your position has to be based on something other than you think he's a liar. If his testimony is consistent with that of the deputy who, when they were not together, gave an identical account of what occurred. You would certainly be free to ask him whether or not Mr. Boatwright was present at the time. It's clear that he was not. So, that's something that if you wish to ask him about, it's fine. But your internal belief that he's not being truthful with nothing else is not grounds for impeachment.
Well
I'm
said.
confused because he's asking for impeachment, but this is outside the presence of the jury. So what is the purpose of trying to impeach him? And he asked him,
He
he
wants to
cross-examined
proffer
him
the
yesterday.
questions that he would ask if allowed to. That's what he wants to do. You can proffer the questions right now, even without him being here.
And also, Judge, he did that yesterday. So we're just going to readdress it again, even though the law of the case is that Your Honor has already ruled. He's not even bringing up a reason why he's challenging or has any redress with the court as to why he's allowed to bring it up again. Your Honor has ruled. He has remedies. He could file something with the 4th DCA. He could do that. I don't understand what we're doing here.
He only has remedies on appeal, not interlocutory for something like this.
If you have him in a lie,
Once again, you can impeach people with
Show him
prior
his statement.
statements,
Show him the
prior acts,
inconsistency.
prior things
Impeach
that
him.
you have some independent
if his testimony's not believable,
way
argue it.
of verifying. You're saying, I think he's lying, is not, that's not a basis of impeachment. That's just your belief. You don't have a previous statement where he did not say that. You do not have a witness who was present at the time who would say that's
She's a
not
little
what
busy at the
happened.
moment.
You just don't believe him. That's not a basis of impeachment.
Judge, I'm asking for a ruling on whether I can.
She might get in trouble if she
You can
checked in
offer your
while the
questions.
defense is at a crossing.
The testimony, please, of Mr. Allen.
His testimony is there. You can proffer your questions.
So is the court denying my request?
Let's hear the question.
Yes.
The questions are, isn't it true, Mr. Allen, that this alleged incident did not occur in this courtroom, correct? Isn't it true that it occurred in a hallway in the jail, correct? And isn't it true that the person that said this was completely surrounded by curtains to the extent that you could not see
No,
the
you
person?
can't do it for the reasons
correct?
previously stated.
Isn't it
Next.
correct that the only way that you believe that it was Mr. Newsom is because you recognized his shoes, correct? And is it your testimony that you saw Mr. Newsom's shoes for all of 2 seconds when he walked into this courtroom yesterday? You
I quit working
remembered,
long ago.
you remembered
That's
not only
Ksenia.
his shoes, but whoever else's
I
shoes
get
are
it,
in this
I get it.
courtroom, and that's how you were able to identify that it was Mr. Newsom who allegedly said it. Is that correct?
Several of those questions are already in the record because you've asked them at the time. And the first set of exactly where it happened, I've already ruled, is not going to come in front of the jury because it would prejudice one of the other defendants and really has no relevancy towards your client or your case. So your objections noted, preserved. The questions you're going to ask are.
That's what we call doing it right.
Thank you.
I'm just pretty sure I have one more meant to mention.
Okay, well, I just, so we're clear?
Yes,
Anything
sir.
else? All right, thank you.
So of the three, there's just one picture here, and this picture has the name Mercedes
And part of what I'm going to be getting, right, part of what I'm going to be getting into is infidelity, how infidelity prompted him to use other phones and do things to avoid the fact that he was being unfaithful. I believe that one of the people that he was being unfaithful with was Mercedes, and the fact that he tattooed her name on her forehead, on his forehead, is such a rare act that I think is indicative of how he feels about her and how scared he would be and the steps that he would take to hide other relationships. And for that, I would ask just this one thing.
That would be denied.
Again.
Okay, that'd be a no.
Oh, we went to the restroom?
Yeah,
Oh,
she's saying-
healthy.
Did he?
Yeah, I didn't
We're in
hear.
session. We should not be leaving the courtroom. Anyway, we can bring Mr. Allen back and while we're waiting for him.
Well, yes, which is a good thing for them to do, but they have so many ways that they can do it, and now they're trying to add other dumb ways that are irrelevant. Just say he lied to get a deal, or imply it via argument. Fine. I'd be making that argument. Any defense attorney in the world would be making that argument in this circumstance. It's a good one. Say it loud, say it proud, and let's not get into his motivation with the extra tat. It doesn't work, and it's beyond the scope, and it's
I
stupid.
did unplug and reboot.
And if you got to do it, a jury wouldn't pick up on it or care.
Is someone coming down to work on it?
Better know.
No, they're in Robbery.
Fat Boy
How
Slim
long is that gonna be?
entering
The roving thing.
I don't know.
All of them need to be there?
I don't know.
the Coliseum. Let's do this.
Judge Shooter's chambers, I can get you the number for them. You can call them up and ask them.
Sure. I'm just kidding.
So until that time, if we need to have a sidebar, the sidebar's going to be jurors going in back
Okay,
until I can get this fixed.
noted.
We had this issue happen once before in my courtroom, and they were able to. There's some.
I'm gonna put a stop to this.
hallway that they're making something on, so once I can get one of the tech people here.
Want me to like YouTube some white noise and don't mess with it.
What I want you to do is stand there and go,
I got you.
and then we can do that, but no, maybe not.
Yeah, stop.
All right, parties are present. Are we ready to proceed?
Yes, Judge. Yes, Your Honor.
Okay, that's fine. And you're marking those as composites?
Yes. I
Okay.
haven't heard that. So.
All right. And,
Yes.
okay.
Yeah.
So you're calling Murphy, please? So this would be like, no. He's like, how are we defendant vote right? How are we identifying it? How are we going to keep them separate? D1, D2, D3? I just want to be able to know what we're referring to as defendant vote right. Exhibit 1, defendant vote right, exhibit 2, whatever. Okay. So we will identify them as defendant and then the names and then 1, 2, 3, 4. No, I mean, I did the same thing. I just, when they get back there, they should be able to know, looking at the sticker, which one it belongs to.
Absolutely. It's a respectful Fat Boy.
They're holding it. Okay, then we're fine. Then,
Others in the restaurant.
After the IG pic showing the neck tattoos, I think he gave it up. We reserve to continue to call him Turtleneck.
No. Yours, Ashley? Thank you.
Parties may be seated. Court will come to order. The parties are present. The jurors are present. Ladies and gentlemen, good afternoon and welcome back. I trust all of you were able to insulate yourselves.
Yes.
Very good. All right, thank you. When last we met, we were in the middle of the cross-examination of the witness by Mr. Boatwright's attorney. So first of all, you are the same Robert Allen that was here yesterday?
Yes.
I remind you, sir, you are still under oath. Counsel, you may proceed.
Thank you, Judge.
And we're out, like a prom dress.
Afternoon, sir. Good afternoon. We left off yesterday where you had told the jury that you had changed your story between 2018 and 2022, correct?
Yes.
And you indicated that the story that you gave in 2018 was to protect yourself, correct?
Yes.
Let's talk about others. You have other friends out in the community that were not any of the gentlemen sitting at this table, correct?
Yes.
All right. You have your best friend is named Robert Morgan, correct?
Yes.
All right. And he's someone that you still talk to on a regular basis in the jail now, correct?
Yes.
You have another friend named May, correct? Someone that you indicated named May.
Sure I said May?
Pretty sure, yes.
I don't know, May.
Okay. You have you do have other friends in the community, though, correct?
Yes.
Commissioner, approach the witness, Judge.
You may. And also, Mr. Allen, it appears that that microphone may not be working right now, so I'm going to ask you to project as well as you can. Thank you. Counsel, proceed.
You had a Facebook account, correct?
Yes.
Your name on that Facebook account was Robbery Rob, correct?
Yes.
And you at times posted pictures of that Facebook account, correct?
Yes.
I'm showing you what we've marked as Defense Exhibit A for identification purposes. I'm going to ask you to take a look at these photographs. There's 4 photographs. And once you've taken a look at them, you can let me know, please. Can I help him, Judge? Can I help him turn the pages?
Or you can lay them all out.
Do you recognize these photographs?
Yes.
These are photographs that you posted to Facebook, correct?
Yes.
All right. You are in all of these photographs, correct?
Yes.
And these photographs all fairly and accurately reflect what was going on at the time that the photographs were taken, correct?
Yes.
Defense would at this time seek to move Defense Exhibit A into evidence and publish to the jury.
No objection.
No objection, Judge, and we would move to adopt these photos on behalf of Mr. Musso.
Well, they're, all right,
Just for the record, I know.
but they're going to be identified as defendant Boatwright 1, so
That's fine.
they're in evidence, and if you wish, you can ask the jurors to consider them on your case.
Understood. Thank you. No objection.
All right, without objection, what was previously marked Defense Exhibit A for identification will be received into evidence as defendant Boatwright Exhibit 1, a composite of 4, and you may publish at will.
Thank you, Judge. Thank you. Sir, I'm showing you now what is one of four from defense one. You recognize this photograph?
Yes,
Who are you in the photograph?
I have on a red sweater.
All right, you're on the far right.
Yes,
Am I correct that this photograph was posted on February 11th of 2018?
yes.
I don't know. I'm
And
thinking the jury might
when it was
read
posted, it was posted with the title "Family."
read gang
Correct.
signs into this without being told. Just
Who is
saying.
this individual next to you?
Andrea.
I'm sorry?
Andrea.
Andrea? Andrea what?
I don't know what that is.
Who is this individual here in the pink shirt in the middle?
Mall.
Maul. Can you tell us Maul's full name, please?
I don't know his woman.
Can you tell who this individual is here next to Maul?
James.
Can you tell us James's full name, please?
I don't know his woman.
Can you tell us who this individual is here in the black on the left hand side?
Hold on.
Can you tell us Polo's full name, please?
I don't know his name.
Showing you 2 of 4.
Yeah, no problem.
You recognize this photograph. Which individual are you?
I want to know all black.
Oh, cut off your head, I'm sorry. Speak up. And this was uploaded on February 25th, 2018, correct?
Yes.
The individual next to you, who is that?
Robert.
It's Robert Morgan.
Yes.
This is the individual who you have continued to have contact with. You call him regularly, even now, correct?
Yes.
Showing you 3 of 4. That's you on the left, correct?
Yes.
And this photograph was uploaded on April 21st of 2018, correct?
Yes.
Who is the individual next to you?
Nate.
What's Nate's last name?
I don't know.
And showing you 4 of 4. That's you on the right-hand side, correct?
Yes.
Who is this on the far left-hand side?
Diedrich Williams.
Same Diedrich Williams who's at trial here today, correct?
Yes.
The man in the middle with the ripped jeans here, what is his name?
James.
That's the same James from earlier, correct?
Yes.
And the man who is next to James,
I don't know.
you don't know him at all?
No.
Am I correct that both of these individuals are taller than Diedrich?
Yes.
And both of these individuals are taller than you?
Yes.
This photograph was uploaded on May 19th of 2018. Is that correct?
Yes.
Less than a month before the shooting, correct?
Yes.
Thank you. Okay. Who did you live with back in June of 2018?
My mom.
Who else?
My stepdad. Who else? Trayvon.
Okay, who else?
Sometimes Michael Boatwright.
Anybody else?
Yeah. A lot of people come stay tonight.
When you woke up on the morning of June 18th, 2018, who was at your house?
I don't remember.
Was your mom at your house?
I don't know if she was there when I woke up.
Was she there overnight?
Yes.
Was your stepdad there when you woke up in the morning?
I don't think so.
Was your stepdad there overnight?
Yes.
When you woke up, was Mr. Boatwright at your house?
I think so.
Okay. You have been asked this question many, many times. Is that correct?
Yes.
In 2018, you gave that statement first to Detective Curcio in October of 2018, and you were asked the question of whether Michael was there. You gave a different answer than you are giving now, correct?
Yes.
When you woke up, was Trayvon at your house?
Yes.
In 2018, when you gave the statement to Detective Curcio, and you were asked that question, did you tell Detective Curcio something else?
Judge, I'm going to object. This is improper impeachment. There are at least 5 or 4 statements, 3 of which are from 2018. And I believe he has to
October of 2018.
page line, please.
I have no idea where he's going with this.
We're not there yet.
Well, I'm objecting to
Maybe we go
improper
sidebar.
impeachment.
Overruled. Did you tell, in October of 2018, did you tell Detective Curcio something else?
Yes.
I'm getting that suspicion.
Were you lying in 2018, or are you lying to this jury now
That covers it right
about
there.
whether Michael and Trayvon were at your house on June 18th, 2018, when you woke up?
So was I lying in 2018?
Were you lying in 2018, or are you lying to this jury now?
I was lying in 2018.
Isn't it true you can't get your story straight about whether Michael and Trayvon were there at your house when you woke up because they weren't at your house when you woke up?
Objection argumentative.
Sustained.
Is there a reason why you would lie about something like that in 2018?
Yes.
What's the reason?
Because I was trying to minimize my involvement.
I understand that, and you have testified to that. How does saying that Michael and Trayvon weren't at your house when you woke up in 2018 minimize your involvement?
Because I believe I told Detective Curcio that they was already at Deidre Williams' house.
And that minimizes your involvement somehow.
Yes, because that would be me saying that I didn't know anything about these guns or anything like that.
Let's talk about
Oh, good Lord. He's trying to say he lied and said that 2 of them were there.
this
And-
rental car.
And
He
that
testified on
implies that he
Wednesday
minimizes
that
the involvement so that
Deidre
his client must not have
specifically
done it.
rented the
Oh.
car to rob people. You remember that?
Yes.
Yeah.
You're sure of
that's
that?
not gonna
as you sit
work.
here right now?
Okay.
Yes.
There's no question in your mind about that.
Yes.
Isn't it true that at the time Diedrich rented the car, you had no idea why Diedrich was renting the car?
Oh, that's
You say, is it true?
that's
That I
pure
didn't
dramatic
know.
hamster.
Correct.
the law was fully aware.
Trying
In
to
your
imply he's really done
October of 2018 statement to Detective Curcio,
false
did you
flat
say
if he
something
didn't.
different?
Yes,
You lied in 2018.
yes.
Judge, I'm gonna object. It's improper impeachment. May we go sidebar as this? It's, the way he's doing it is improper
Hold on.
impeachment.
All right, ladies and gentlemen, my sidebar thingy is not working, which is why the microphone system seems to not be working. I've asked someone from court system tech to come down and take a look at it, but until they do, and I don't have someone to stand by and go the whole time, so I'm gonna need you to step in the back when we have sidebar. Apologize about that. Thank you for your comment.
State your name for the record, ma'am.
These nuts.
Okay, thank you.
I don't know why the volume's not on. I don't know why.
If he's not properly doing it.
There we go.
I don't understand the state's objection. The witness is saying something today that is different from what he said in October of 2018. I asked him, have you said something different in 2018? That is the next step. And up to this point, every time he said yes.
And he's admitted it. So if you're going to
All right.
impeach someone, he's admitted it.
But if he said
All right.
no,
Instead of you two arguing with each other, the court will make its ruling. I have some understanding of 608 and impeachment rules. You can ask a question. Did you make a statement at such and such time that was different? You don't have to ask the exact question. You can just ask the question, did you make a different statement at such and such time? The witness says no. Now we're going to say page, line, date, where, all that kind of
Oh,
stuff.
good Lord.
And give them an opportunity to be
We're in first
refreshed
year
if
trial
necessary, and then ask it again. When the witness says, yeah,
Oh, sweet Jesus. What?
and that's the procedure. And that's the way it's set up in the law. And that's the way we've been doing it for a long time. So up to this point, Mr. Kimmock's questions have been appropriate. He's asking, did you make a different statement? And the witness himself has said, yeah, I lied at that time. So he's admitted to these inconsistencies. So if you were now to say, all right, let me pull them out and show them, no, that would be improper.
He's impeaching a consistent statement.
But the procedure at this point is correct. Your objection's overruled. Thank you, Judge. Anything further?
No.
Thank you. Bring them on.
Yes, sir.
Okay, that'd be a no. No, you may not.
Charge entry.
Parties may be seated forward from the order. Parties present, welcome back. Council may proceed.
Thank you, Judge. You told this jury that you know that Diedrich rented the car to rob someone, correct?
Yes.
You weren't assuming, correct?
Yes.
You weren't guessing, correct?
Yes.
You know, correct?
Yes.
In July of 2022, so 8 months ago, when you gave a statement to this prosecutor, did you say something different?
I don't remember.
Excuse me?
I don't remember.
If I showed you a copy of your deposition, or excuse me, of that statement, a transcript of that statement, that would refresh your recollection.
Yes.
2022 statement, bottom of page 8, top of page 9. I'm sorry, I should have asked permission. May I approach the witness, Judge?
You may.
I ask you to start at line 19 and then go through line 5 of the next page.
Shit's a long what?
Line 5. 6, yeah.
The part that says,
You can read as much as you want. You got it? That refresh your recollection as to whether you said something different about that in July of 2022.
Yes.
And did you in fact say something different in July of 2022?
Yes.
Something different than what you have told this jury about whether you knew that Diedrich rented that car to rob someone, correct?
I said I assume yes.
You said, I guess, and I assume,
Yes.
correct? Were you telling the truth to this jury?
Jay? You say I'm
I'm
gonna
gonna
tell
ask him to speak up. I'm sorry, Judge.
When you testified about that, when the prosecutor was asking you questions, when you said you knew that Diedrich, that's why Diedrich rented the car, were you telling the truth to this jury?
yes.
okay, give him the hook.
Told this jury that the whole plan that day was to ride around and rob people, correct?
Yes.
Back in October of 2018 to Detective Curcio, did you say something different?
I believe so.
Do you want to see the statement to refresh your recollection on that?
Yes.
Oh, good Lord. He doesn't have it
Go to the
ready.
October 23rd, 2018 statement, page 61. If you could start at line 13, and you can read as long, you can read to the bottom. So line 13, start at line 13, read to the bottom. Did Detective Curcio ask you if you knew what they were getting into that day?
Oh, okay, yeah.
Yeah. Does this refresh your recollection about what you said back then?
Yes.
And with regards to whether there was some sort of plan to rob someone, did you say something different in October of 2018 than what you were telling this jury during this testimony?
Yes.
Actually, let me keep this for a second. And am I correct that during this conversation back in October of 2018, did you feel like you were being pressured by the police to say something that you didn't know?
No.
Back in 2018, did you say something different?
You're gonna have to be more specific.
No.
Sure. Back in October of 2018, did you tell the police that you felt like they were trying to pressure you to say something that wasn't true?
I don't remember.
If I showed you a copy of your statement, would that refresh your recollection?
Yes.
Bottom of page 61, line 23. Back in October, does that refresh your recollection as to whether back in October of 2018, you felt like the police were trying to pressure you to say something that wasn't true?
Yeah.
Did you feel like the police were trying to pressure you to say something that wasn't true?
I really don't remember.
You remember saying it now. Is that correct?
Yes.
Again, after the October 2018 statement, you said there was no plan. State refused to make a deal with you, correct? They didn't make a deal with you in 2018, correct?
No.
They didn't make a deal with you in 2019, 2020, or 2021, correct?
Correct.
I don't know that I'm...
That's you. They're fixing the audio, but I'm telling them this is probably not what we had in mind.
No.
What the hell is that noise? Are they doing a reno in the next courtroom? It's better than this guy's cross. What the hell? Hammer time.
Now, you didn't say the cat jumped on his wiener, did you?
The wheels of justice are going to roll you right into the Wayne County Jail.
Mr. Allen, say something into the microphone.
Yes.
Yeah, no. All right, sorry. See,
Thank you, Rich. Between 2018 and 2022, your story changed about whether there was a plan to rob someone, correct? Yes.
Well, that's Polar Spring Premium Seltzer.
You told this jury yesterday that, it may have been the day before, that everybody left Diedrich's house with a gun, correct? Yes. You said all four of you had a gun, correct? Yes. And your testimony was that you were planning to do a robbery, and that's why everybody had a gun, correct? Yes. Back in 2018, when you were under oath, as you are now, did you say something different about that? Yes. The first time that you saw a gun, was it at the time that right at the moment that the robbery was about to take place? Can you repeat that? Sure. The very first time you saw a gun on June 18th, 2018, was it at the moment that the robbery was fixing to take place? No. Back in 2018, October of 2018, in the statement to Detective Curcio, did you say something different? Yes. When you were getting into the Dodge Journey at Chucky's house, so you're at Chucky's house, you are getting into the Dodge Journey, did you know there were guns in the car when you got into the Journey? Yes. Back in October of 2018, when you were talking to Detective Curcio, did you say something different? Yes. The rifle that was actually used in the shooting, did you see that rifle prior to the robbery? Yes. Back in October of 2018, when you were speaking to Detective Curcio, did you say something different? Yes. You told this jury that you first saw the rifle come into the car with Michael, correct? Yes. Back in October of 2018, when you were under oath and speaking to Detective Curcio, did you say something different? Yes. You told this jury that you specifically saw Diedrich with a gun, correct? Yes. In fact, the prosecutor showed you an actual gun, and you said that was the gun that Diedrich had that day, correct? Yes. And you said that you saw Diedrich, you said to this jury that you saw Diedrich with that gun June 18, 2018, correct? Yes. back in October of 2018, when you were speaking to Detective Curcio, did you say something different? I showed you a copy of that statement. Would that refresh your recollection?
Yes.
While you're doing that, let me pause you. I just want to try this. Okay, thank you.
Page 21, the top of page 21. You know, I need page 20. Sorry. So it's the bottom of page 20, line 24, and top of page 21, line 7. Start. So you told this jury that you saw Diedrich with a gun on June 18th, 2018. Back in October of 2018, when you were giving a statement to Detective Curcio, did you say something different?
Yes.
Let's go to July of 2022. When you were, well, you just told this, or you told this jury that you knew that there were guns well before the robbery, correct?
Yes.
In the July 2022, when you were being interviewed by this prosecutor, just 8 months ago, did you say something different?
I'm not sure I remember.
I showed you a copy of that. Would that refresh your recollection?
Yes.
Page 9, line 21. Good look at page 9, line 21. Just read the question and answer. You told this jury that you knew that there were guns in that car long before the robbery started. In July of 2022, just 8 months ago when you were being interviewed by this prosecutor, did you say something different?
Yes.
On Tuesday night, when the prosecutor came to see you, did she talk to you about when you had first seen these guns?
No.
When you arrived at Revo and you were going into the store, who had the keys to the journey?
I don't remember.
Was the car turned on or was it left off?
I don't remember.
Going back to talking about the guns, you described in detail for this jury the guns that you say were there that day, correct?
Yes.
You said that Newsom had a .38, correct?
Yes.
you said that Michael had a GSK 22, correct?
Yes.
And you identified a gun that you said was Deidre's, correct?
Yes.
Back in October of 2018, when you were being interviewed by Detective Curcio, did you know the caliber of the guns that you say had been in the car with you?
Yes.
And did you say something different to Detective Curcio in October of 2018 about whether you knew anything about those guns?
Yes.
When asked what kind of gun Michael had in October of 2018, did you say something different than what you told this jury?
Yes.
When you were asked what caliber of weapon Trayvon had in October of 2018, did you say something different than what you have told this jury?
I don't remember.
If I showed you a copy of that statement, would that refresh your recollection?
Yes.
You look at, this isn't the right one. Not that one. Come on. Is there a reason your story has changed about the caliber of weapons that were involved in the robbery?
Yes.
You told this jury that when you were in Riva, you tried to call Michael, but it did not connect. Is that correct?
Yes.
Specifically with regards to whether it connected or not, whether you actually spoke to Michael. Back in October of 2018, when you were speaking to Detective Curcio, did you say something different?
Yes.
You said that you had spoken to Michael, correct?
Yes.
Going to 2022. All right, well, let's start here. At this trial, you have told this jury that the reason you called Michael was to confirm that it was X that was in the store, correct?
Yes.
In July of 2022, just 8 months ago, when this prosecutor was interviewing you, did you say something different about the reason that you called Michael?
I don't remember.
Did Diedrich ask you to call Michael to see if Michael needed anything in the store?
No.
Would it refresh your recollection as to whether you said anything different if I showed you a transcript of that statement?
Yes.
Page 10, line 11. Page 10, well, it actually kind of starts up at line 4, I guess. Line 4 down through line 13. Okay. All right. So you've told this jury that you called Michael to tell Michael what that X was in the car, correct?
Yes.
In July of 2022, did you say something different?
Yes.
That was just 8 months ago to this prosecutor, correct?
Yes.
Is there a reason your story has changed between July of 2022 and your testimony here today, the last 3 days?
Yes.
He's actually making the guy look more credible.
Isn't it true that that story keeps changing because you never called Michael on June 18th, 2018?
I called him.
Let's talk about why this, what the plan was in when you were going to perpetuate this robbery. Was the plan
It's
to
looking that way.
rob X of his jewelry, or was the plan to rob X of the bag?
The bag.
In October of 2018, let me back up. The plan was the plan specifically to avoid the jewelry?
Yes.
Why is that?
Because of a crowd block on it.
All right, and that was something that you discussed.
Yes.
Back in October of 2018, when asked what the plan was, what you were trying to take, did you say something different?
I believe so, yes.
Okay. You believe so or you know?
Can I see something? So we're trying to move it.
Yes, absolutely. Page 24, line 10 through 14.
Well,
Does that refresh your recollection about whether you said something different in October of 2018 about whether the plan was to rob X of his jewelry?
yes.
You've told this jury that the plan was to rob him of the bag, correct?
Yes.
In October of 2018, did you in fact say something different?
Yes.
You told this jury that on the way, that after the robbery, while you were driving south from Pompano, that Michael looked in the bag while you all were in the car, correct?
Yes.
In October of 2018, when asked whether anyone looked in the bag on your way down from Pompano, did you say something different?
Yes.
Is there a reason why your story changed between October of 2018 and now about why anybody looked in the bag?
Yes.
let's talk a little bit more about the money. Judgment approach. Showing the witness it's been marked as defense B for identification. Ask you to look at these photographs. Tell me if you recognize them. Composite of 4 photographs. Recognize these photographs?
Yes.
Are you in all of these photographs?
Yes.
These photographs are taken after the robbery, correct?
Yes.
And they were in a hotel room up in, I think, Fort Pierce, is that correct?
Yes.
Do these photographs fairly and accurately reflect what everything looked like when the photographs were taken?
Yes.
Defense seeking to move defense B into evidence.
No objection.
No objection. Objection.
Without objection, what was previously marked defense exhibit B for identification shall be received into evidence as defendant vote rights exhibit 2, a composite of 4.
Permission published.
You may publish it, Will.
Showing you 1 of 4. Who are we looking at?
Me.
That is, what's in your hand?
Money.
Where'd the money come from?
Robbery.
2 of 4. Whoops. Also you, correct?
Yes.
All right, taken same time, same place, correct?
Yes.
3 of 4, correct? That's still you, correct?
Yes.
Taken same time, is that correct?
Yes.
And 4 of 4. 4 of 4. Is that also you?
Yes.
Also flashing money from the robbery?
Yes.
In 1 of 4. 1 of 4, you are in a hotel room in Fort Pierce because you were fleeing from Broward County, correct?
Yes.
Isn't it
And
true
Michael
that you
was
ate through
there
that
with
in 3
you
days?
at that time, correct?
Yes.
Also, same hotel room, same time, correct?
Yes.
Michael was also there, correct?
Yes.
Same hotel room, same time, correct?
Yes.
Michael was there with you, correct?
Yes.
You informed this jury during direct that you got $5,000, correct?
Yes.
And you informed this jury that Michael got $15,000, correct?
Yes.
You informed the jury that Trayvon got 15, correct?
Yes.
You informed this jury that Diedrich got 15,000, correct?
Yes.
Yeah, we have pictures of it.
Michael didn't get 17.
Nice job implicating your
Correct.
client once again.
No.
In July of 2022, when you were being interviewed by this prosecutor just 8 months ago and you were under oath, did you say something different about the amount that Michael received?
I don't know.
If I showed you that statement, would it refresh your recollection?
Yes.
Now, we're on page 23 of the 2022 statement, beginning on line 23 and going to the next page. Start right there. You told this jury that Michael got $15,000, correct?
Yes.
Did Michael get $17,000?
No.
In July of 2022, just 8 months ago, did you say something different?
Yes.
Is there a reason that your story has changed about how much money Michael got between July of 2022 and now?
Yes.
You told this jury that Trayvon got $15,000, correct?
Yes.
Did Trayvon get $12,000?
No.
In July of 2022, when this prosecutor was interviewing you and you were under oath, did you say something different than what you're telling this jury now?
Yes.
Is there a reason that your story would change about how much money Trayvon got between between July of 2022 and now?
Yes.
You told this jury that Diedrich got $15,000, correct?
Yes.
Did Diedrich get $12,000?
No.
In the July of 2022, when you were being interviewed by this prosecutor and you were under oath, did you say something different?
Yes.
Is there any reason at all why your story would change about how much money Diedrich got between July and now?
Yes.
Isn't it true that reason is because Michael and Trayvon
No,
weren't
he's questioning his
included
client.
in the money cut?
It's absolutely counterproductive to his
They didn't
cause.
get any money.
Definitely got money.
It was other people, correct?
This is not a good cross-examination.
What are you saying?
Who got money?
No, Michael Goldberg and Trayvon Newsom got money.
Well, he gets that he's a liar. We all know that. And he questions his accounting.
Were
The fact
you
remains,
lying to the prosecutor in July
putting
of
proceeds of the
2022?
crime in his client's
Told them
hand
something
and
different.
reminding the jury
Told
of it
this jury.
repeatedly.
Yes.
Is there a
It's
reason
incredibly
that you
stupid.
lied to the prosecutor in July of 2022 about how much money people got?
Yes.
Did you lie, or is it you just can't keep your story straight?
Objection,
I'll withdraw.
argument.
I'll withdraw.
We will disregard the question.
When you got back to your house after Reba, who was there that lived at your house?
I don't remember.
Who was there at all when you got back to your house?
I don't remember.
Was there anybody there?
I don't remember.
You said on direct that, well, let me go back to the house thing. It's your testimony that Michael and Trayvon came back to your house, correct?
They all three came back to my house.
After Reba, correct?
Yes.
Was there anybody else
didn't need.
there who would have seen you?
Objection asked and answered, Your Honor.
Nice to see you. I'll catch you up. This here convicted killer is also sometimes
Was there
dishonest.
anybody else there at the house who would have seen them?
I don't remember.
You said on direct that Michael changed clothes
Right here, Kel Murray.
after the homicide, correct?
Yes.
And you told this jury that he changed into his own clothes, correct?
Yes.
And you said that he did that because he had clothes at your house, correct?
Yes.
Did Michael didn't change into your brother's clothes?
No.
In October of 2018, when you were being interviewed by Detective Curcio, did you say something different?
Yes.
So which is it? Did Michael change into
His own clothes, or did he change into your brother's clothes?
He changed his own clothes, but the hat was mine.
Is there a reason why your story would change about whose clothes Michael changed into between 2018 and now?
Yes.
Isn't it true that the reason you haven't been able to keep your story straight about what clothes Michael changed into is because Michael never changed into any clothes?
He changed.
I'm going to show you the part of what was introduced. This is States 3 was introduced yesterday. You see that? The picture come up in front of you there?
Yes.
These two people, who are these two people?
Michael Boatwright and Trayvon Newsom.
All right, and this is at 5:30 p.m. at the Driftwood Apartment Complex, correct?
Yes.
I might pop on her stream later and say hi.
I'm gonna ask some questions about it. Michael's wearing shorts in this video, correct?
Yes.
He's wearing a t-shirt, correct?
Yes.
He's wearing a camouflage hat, correct?
Yes.
There are no guns on him, correct?
Yes.
He's not carrying any bag, correct?
Yes.
He's not carrying $15,000, correct?
I wouldn't know if he's carrying $15,000.
Okay, so do you think that there's an ability for $15,000 to be carried in those, whatever he's got on?
Yes.
Yeah.
You would agree with me he's not running, correct?
15,000 C notes is not a big
You would
pack.
agree with me he doesn't appear to be in any hurry, correct?
Yes.
The prosecutor asked you on the first day if the gait and manner of Michael on this video were the same as the gait and manner of the shooter at Riva Motorsports. You remember that?
Yes.
And you said yes, correct? You agreed with the prosecutor about the gait of the Michael in this photo being the same as the gait of the shooter at Riva, correct?
No, I don't remember that.
Okay, fair enough. So it's not your testimony then that the gait and manner of this person is the same as the gait and manner of the shooter at Riva?
When you say gait and manner, you saying the way they walk, right?
Yeah, that's it.
They don't walk, sir.
Thank you.
I don't think this guy will finish today. And we have two more.
I'm going to fast forward now to the crash.
If I was representing one of the other defendants, I'd be pissed. He's absolutely annoying the hell out of the jury. And screwing up any chance you have to argue on behalf of your client.
I don't know. Technology's a little slow. It looks like we're frozen. Do we have a brief comfort break anyways, or try to fix what? Technology issue?
Certainly.
It's just frozen.
Let's take a 5-minute comfort break. Members will take it back there, you let us know when you have an opportunity to use the restroom. We are in recess.
Okay, there was, and I hate, God, I hate this one. They throw a bunch of dick pussy, dick pussy, dick pussy, dick pussy, going back and forth between tents with one another, and I never want to hear it again.
I do. I can't hear it enough. Oh, I'm hoping one of his co-counsel pulls him aside and says, knock this shit off. You're destroying any chance any of us have to defend ourselves here. You made your point, he's a liar. Get shut up and sit down. That probably won't happen. And if it does, it won't matter much, but that's what we're dealing with here.
I'm going to use Miss Fowler's words. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
He was dry humping all that, dude.
Oh my God!
Yeah, that's what I was saying. He was getting after it when I pulled up.
I can't remember which one that is. Somebody in the chat tell Nicole where that video is. I've got so many from Judge Manning. I can't remember which one that comes from now. I don't know what I called it. What's on the thumbnail? Help me out. Do me a solid. The traumatized backpack. Let's traumatize Ben. Bring back some memories, Ben.
Girl. Yeah, I proved it. Girl, no, don't do that. Just I will mute you now, Miss Jones. All right, now, no more girl, Miss Barnett. Now you tell me.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I suppose.
$25,000.
That's so dumb.
I know, it's ridiculous, isn't it? It's stupid.
They told me it was $2,500. Yeah, you're going
Here,
down.
give me, no, ma'am, you're right. It is crazy. Let's change that. Bond's 50,000.
Never basically pulled anything out. So you can talk with your attorney about that.
Yeah, ma'am. Well, I'm going to expose myself. And
What do you want?
Lordship, my senior will not be here.
What do you want?
Lordship, another day, Lordship.
Excuse me, can I ask a question?
No, place your screen on mute.
stay out of Fulton County. Sorry, the only reason you're going to come to Fulton County is court or to see your lawyer. Not even get gas. Can't even stop at Chick-fil-A. Stay away.
Great morning. All right.
Okay.
I am Judge Lanice Bryant. Welcome to the 36th District Court. You are at the 36th District Court. You are at 36th District Court. You are at 36th
Where are we,
District
Judge?
Court. You are at 36th District Court. You have lost.
Annie is asking very nicely for you to like, subscribe, and hit the bell notification. And if you ignore Annie, you do realize that that is considered capital felony treason.
Have you ever had a failure to appear?
Possible. Oh man, I gotta get together.
I really do enjoy my clips. They give us a time frame on this.
Oh, look at your attitude. Like I did you something. Girl, I haven't done you anything, I promise you.
Have you ever had any history of substance abuse issues?
I smoked a lot of weed.
Oh, there's so many good ones like that that I need to clip that I didn't. I need to improve my clip library. Oh, good Lord. Oh, good Lord. Oh, he wants to get in on this ceiling action? No problem. Let me see. Check email.
Oh, sweet Jesus. What?
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack, and
Mental health with marijuana. Only thing is going on is that maybe when you high, you don't be thinking about your mental health. That's not treatment. That is not treatment. Okay. So,
oh Lord.
Flip the camera.
Cut that camera, please, Mrs. Tang, because I don't know what's about to happen there.
Car accident, this is the Dodge Journey, correct? Yes. I'm gonna watch it and I'm gonna ask you a couple questions.
Mr. Kimok, if I could ask if you could just tell us the timestamp of where you're starting from, please.
We're at 13:20 right now.
Thank you.
Michael is nowhere in that video, correct? Yes. You told this jury that Michael was the one who was driving at the time of that crash, correct? Yes. Was Trayvon driving at the time of the crash? No. Back in October of 2018, when you were under oath and you were describing what happens to Detective Curcio,
Good Lord, he
did you say
continues.
something different? Yes. Were you lying about that in 2018?
Yes.
Is there a reason why your story would change about who was driving the car, Trayvon or Michael, between October of 2018 and today?
Yes.
Forward a little more. I'm not going to fast forward it. I don't want to freeze it again. Let me go ahead about 2 minutes. This is a car that, I'm sorry, I stopped it at 1620. This is the car that you ended up getting into, correct?
Yes.
Who was driving this car?
I don't think it would be appropriate to talk about who was driving that car.
Okay, so you don't think it would be appropriate to talk about who was driving the car?
Yes, as far as my safety, yes.
Okay. This is when you get into the car, correct?
Yes.
You're getting into the back seat of the car, correct?
Yes.
What is this that you have in your hand?
Hat.
The camouflage hat, correct?
Yes.
This incident that you say happened with Trayvon yesterday, Michael was nowhere to be found at that point, correct? I didn't say no. He was nowhere around, correct?
Yeah.
None of the attorneys that are in this room were there, correct?
No.
The judge didn't see this happen, correct?
No.
You told this jury that you have not been promised anything for your testimony, correct?
Yes.
You said the state, and the prosecutor asked you if they even hinted to you what it is that they're going to give you as a sentence, and you said no, correct?
Yes.
You have talked to your attorney, correct?
Yes.
And your attorney has talked to the prosecutor, correct?
Yes.
Isn't it true that your attorney has repeatedly told you that you're going to get 5 to 6 years on this murder case?
That was possible.
That's what he keeps saying to you, correct?
Yes.
Make it up 1 minute, Judge.
No hurry. Just whenever you get to it, it's fine.
Almost done, Mr. Allen.
Oh,
I want to give you
praise the Lord.
one more opportunity
TL, baby.
to talk about whether you have been promised anything. You talked about the fact that the prosecutor has already changed the charge for you from murder in the first degree to murder in the second degree, correct?
Yes.
Has the prosecutor given you any other benefit whatsoever already in exchange for you agreeing to testify?
I don't understand what you mean by benefits.
Has the prosecutor given you a benefit, given you something that is beneficial to you?
Giving me as of what? I don't understand what you're asking.
Has the prosecutor given you any plea deal
Thank you, Kat in Virginia.
as a benefit to you?
Yeah.
Open please.
It's at the 2 hour, 6 minute mark.
Okay. Has the prosecutor given you any plea deal to any other case?
Maybe any other case.
Sure. At the time that you were arrested on this case, you were on probation, correct?
Yes.
You were on probation for 12 separate felonies.
Judge, I'm going to object to this line of questioning, and I would like to take both sides.
Oh, come on. What's 12 felonies between friends?
Hey, just
What's
stay
going
at the
on, brother?
ceiling. Not much.
They're trying to keep, the prosecutor's trying to keep out the 12 felonies. I don't care. Eat it at this point. They have a videotape of the guy involved in conspiracy where they shot somebody in broad daylight. Who cares about the other 12?
Maybe they should try and bring out the fact that he lied. Just saying.
Nobody.
Maybe.
I don't know. I don't do defense, but I would hit him with maybe 1 or 2 examples, or just get him to admit it. He admitted the first couple that
Right.
he asked him. Did you lie about this? Yes. Okay. Do that 2-3 times, and then in closing argument, say the guy on the stand
An
said he lied.
admitted liar,
How can you
right.
trust him? Great argument to make, and the jury doesn't hate you.
Right. I got you, man.
All right, so I see you've got a big stream coming up tonight.
Yes, a big stream.
Body language.
Yeah, well, I was working on well, the Super Bowl and Valentine's Day are only like 2 days apart this year, so sort of a Super Bowl Valentine's Day mashup. And but Derek has Army duties this weekend, so we recorded it yesterday. Anyway, it got to be like almost 53 minutes. I'm like, screw it. I'm just put this as a standalone now. I was just gonna put it as part of my thing. I didn't think it was gonna be. Yes, so if you want to know if someone likes you, you should watch. Know the cues of body language.
Oh, it's
we
the
have
Valentine's Day edition.
Yes, the Valentine's Day edition. So, yes,
That's
we
the
have a
hearts on the
lady who
thumbnail.
claims, a young lady, yes, who claims to be in love, and you will see if she is in love or
I can
not.
tell you, I'm an expert in this.
Well,
The answer
everyone
is
loves
she
you,
doesn't.
Mike. Come on.
She doesn't
Everyone
care.
loves you, so it's easy for you to figure it out.
100% of the time.
The rest of us, folks, we have a tougher time.
She doesn't
we
care.
We don't all walk around, like Mike. Everybody loves me. So, for the rest of us, folks, we need help. So, figure it out.
Yes, people are confused on these issues.
Yes. So I was planning on something for Saturday, so I still might. I'm working on it, like I say, Super Bowl. So I might have some trivia. I might have some chick flick Super Bowl trivia mashup there. So a little something for everybody. But we'll see.
That all sounds good, my man.
Well,
Wait, let me check in, make sure we're not missing the.
All right, yeah, don't miss it.
Oh no, we've got the wall.
The wall. Wait, why did they switch from the ceiling to the wall? What is going on?
I don't know. This trail makes me crazy
What's
because
that on
it
the
has
wall?
such good parts, and then
like a Wi-Fi. Oh no, that's a door. Sorry, I was like looking at that gray thing there. I thought it was like a Wi-Fi router, but it's like it's a door. Okay.
But yeah, this guy's cross-examination is absolutely killing me. What are you gonna do?
Well, I don't know what you're gonna do.
Seriously, first of all, I don't know why they didn't sever it. But if I'm representing one of the other defendants, I'm like, dude, you've got to stop. Now he doesn't have to. They don't have to like work as a team. They often don't. But
right.
If I could, I'd grab him and say, like, you've made your point, knock it off.
Yeah.
Can you imagine? Because then, all right, so then you do this. Your co-counsel, well, whatever, the co-defendant's counsel goes up there, just absolutely destroys this jury. The courtroom's in flames. And then and then they go, okay, it's your turn for cross. And you actually have some cross-examination. You're like, oh, God.
I know.
You're walking into this horrible setup,
Right. He's like,
can
we take a break?
Celebrating right there at counsel table. Like I'm cutting down my cross as we go.
Right. There's really nothing good. This guy. I mean, that's really all they've got is to show this guy is a liar, therefore he can't be trusted. But
yeah.
I mean, I think maybe if you had a dead horse, maybe you could bring it in there. They could beat it.
I got so excited when he said I'm almost finished, but I don't. Although he seems to be, because he's done with the transcripts and he's on to the here's the deal you cut. We all get it. It's a great argument. You had an incentive to implicate these people. The problem is the problem is it's backed up by the video. So the jury's going to say, yeah, he's not a trustworthy guy, generally speaking, but when he's testifying consistent with the freaking video of the crime that we saw,
tends to be more credible and believable. Yes.
His credibility isn't much an issue.
Yeah.
Oddly enough, aside from the issue of identification, but that I think the state's got that nailed here. I do. All
Yeah,
right.
the
So is your video live or is that like a premiere?
no,
Like
it's
you
gonna be
already
a
filmed?
premiere. Like I said, we pre-recorded it because I was just gonna include it. I didn't think it was gonna be so long, but when it turned out so long, I was like,
All right. Well,
make
maybe
it a.
I'll learn something.
But no, I do have another one, man. I will. Just happened yesterday, and it's crazy. Some attorneys are really dumb. You working with attorneys, that might come as a shock, but they do dumb things.
So now that you're booming along there, over 4,000 subscribers, do you get do any of your colleagues know that you do this?
I don't know. I don't think so.
Oh, Dickerson knows.
Dickerson knows.
I know
There's
he knows.
I think I haven't seen her in a long time, but she used to be here on your chat. She's an attorney here locally, and I know she was following the Blandino. I haven't seen her in a long time, but I know she is there and she knows. She's said something to me, but
That's kind of fun.
yeah, it's fun. But I don't really want to. I don't know. We'll see.
Well, no, it's not like you can. You can't bring it up. Otherwise, you look like this guy.
I don't know how to put this, but I'm kind of a big deal.
Yes.
Nobody wants to.
So no one wants that. And then you get the robe; it's open. Who wants that? Who wants that? No one wants to see that much chest. I don't think I know anyone that would want that. Is that even a thing?
All right. What are they? My God, they started this thing at a nice leisurely 1 o'clock in the afternoon because apparently the judge had a call in the morning. Then they leisurely argued about stuff that should have been settled already for an hour. And then this guy, I think we ended the day with him in cross-examination, and he's going to take the whole day. One of the 3 attorneys on cross-examination.
So what time is it? It's almost 4 o'clock on the East Coast.
Yeah.
Almost 4.
And this judge doesn't care. He's not staying over. He's already said it. He's going fishing tomorrow. Not on a Friday. You're not holding a jury till 6 o'clock in the afternoon on a Friday.
On a Friday?
No way.
Well, I mean, you can't get an attorney to. You can't get an attorney to work past noon on a Friday.
No.
I mean, come on. Come on.
They think they're going to take forever. I was thinking about doing this trial. I'm like, no, this thing is going to go on for a month. I'll keep up with it, but I can't do the daily. I just did the first week here. I thought yesterday the witness intimidation was riveting, and I thought the actual video of the crime was riveting, and the prosecutor going through the video with this witness. This guy's been on the whole time. He's the second witness.
Second witness or second attorney? Or
yeah,
what?
The first one was the step uncle who spoke very lightly and with a little accent. The accent wasn't so bad; you just couldn't hear him. And then this guy, and we're day 4 on this trial.
Ugh, what a nightmare.
So the problem going into next week, I think at some point they're going to place all these guys at the scene and in the car with DNA. Because she was asking about the prosecutor was asking
all the forensics,
the fingerprints off and all that stuff. So I think she was laying the foundation for a later DNA that's going to come in saying these guys were all in the car.
So there must not be fingerprints. Is that what you're thinking? Or
maybe it's fingerprints.
Well, what was his answer? Did he say they wiped down? Did they say that they wiped down the car?
7 hours of testimony to get what we already know, which is all these knuckleheads were in the car.
And that guy's a liar. He lied once.
And that guy's a liar.
He lied.
I did, and then he's fussing about the amounts of cash. Oh, it wasn't 17, it was 15. You're still putting the proceeds of a murder into the hands of your client and reiterating the fact numerous times. What the hell is wrong with you?
Oh, I know. Yeah, this is like the clients. This is when people, oh my goodness, when they're chirping in your ear when the person's testifying, you're trying to listen, and it's like, oh man, they're lying. You know, it wasn't 17, it was 15. It's like, okay, shut up. Let me listen.
It was kind of awkward when the judge had to explain to him the process of impeaching a witness. He didn't get it. Like they had a whole sidebar about it. You want to impeach? You asked the witness if he lied. He said yes. Well, you don't impeach him. He just friggin' said yes. What do you want? It's over. You've got him to admit on the stand that he lied. That's the goal. You've achieved.
Well,
it.
if he admitted to lying, if you impeach him, then that would be showing that he told the truth.
Then you're lying about lying. Like he doesn't get the concept.
You're lying about lying. Yeah.
Oh.
Yeah, that's a problem.
I always wondered that. Like, did they use the money to hire attorneys? Yeah, I have no idea what these guys do. But do you guys have to like show the proceeds? Like, do you have to show that the proceeds came from a reputable place or something? Like, can they be like?
No, I think there's
these drug dealers who come in and have millions of dollars for the defense.
Right. I think like money. See, you can tell that lawyers regulate lawyers, because I'm fairly certain that money paid to an attorney is considered communication, but we do have source hearings for bond. So if someone's going to pay are you frozen? I'm just like talking to nobody there. Wait, you there?
No, I'm
so
here.
we have source hearings for bond. So if someone's going to post a bond, say, okay, the bond is set at $10,000, $20,000 with a source hearing. So then you have to show. I had one like a month ago, and so we went in. It was his sister and his aunt paid. They went in with showed their pay stubs. They pawned, and the receipt or the contract with the bail bondsman. They showed pawn tickets too. They had pawned jewelry, some of the defendants' jewelry, to pay for the bond. So then the judge was like, "Yep." So he said, we submitted all that stuff, showed where the money came from that paid for the bond. Because otherwise, if you're accused of, usually, in drug cases or prostitution or something like that, they're like, where did this money come from? You paid bond in like wadded up, moist $1 bills. Where did these come from?
So they probably don't have to do anything here. So could they have used $15,000? Yeah, I would think that these defenses would cost a lot more than that. These guys are gang members, so any money they have is ill-gotten. Let's be honest.
How long after this happened were they arrested? Because I know they didn't like that. $15,000 was probably spent, I'm guessing.
Oh yeah. It's long gone before that.
They didn't invest in a long-term. Yeah.
Skate through his, in 3 days.
Right.
So, it's not.
Yeah, I don't think these guys are like investing for retirement. I don't think they were thinking about that.
And all these guys, none of them. I'm guessing. I'm making assumptions, but I'm guessing none of these guys have legitimate jobs. The only time they ever get money is is the proceeds of some crime.
Right.
They've got felony convictions, so if they really wanted to work, it'd be hard anyway. Face tattoos. I think they're just limited to proceeds of crime, basically.
Yeah.
From record and skill set and everything. All right.
I think the chat's all upset because I said the word moist dollar bills. So I'll repeat it. Moist.
Oh, good Lord. I just want to see this guy finish. I just want to see this guy say, I am done with my cross-examination.
No further questions, Your Honor.
No further questions. I'm
Oh, I
going
need
to
my
go sit down.
I need my confetti cannon like I had the other day for Biggins' birthday. When he ends his cross, I can.
Well, I've only heard one of them speak. The three defendants haven't spoken, but yeah.
Oh, look,
Yeah,
Biggins here.
one on the stand's no Mensa candidate. All right. I mean, how long? I mean, I guess they went
Moist
2
and
hours. The
gusset
jury
belong.
only went 1 hour, though.
Are we? What? Yeah. What is the break we're taking? This isn't a sidebar, right? This isn't
Wait,
a.
what do you want? What do you want me to stop saying, Calmary? Moist?
I think moist. You know, there's other words that rhyme with moist. Are they also
What are you
offensive?
asking me to stop saying, Calmary?
I think she's axing you to stop saying moist.
I
What
think
about
she's
words
asking me
that?
to stop saying moist.
I think she's axing, but she didn't say please. She wasn't axing nicely. But well, like hoist, joist, are they offensive too? Is it just moist? Foist. What other? Anything else that rhymes with moist? Hoist, joist, foist.
All right. Yeah, come on. This dude is going to come out there and say we're done for the day. I want to go fishing.
Damp, all a bit down. Damp
Ready to
isn't.
go home. Yeah,
Isn't as good.
this trial is going to go on forever. I'm going to monitor it because some good stuff is going to happen. I actually wanted to see. I wanted to see when the defense attorneys, but I don't know if they're going to put on any cases because they're not going to put their clients on, right? If you're okay, put yourself in their shoes. Just like spitball, though. Who would you put on?
No,
I think the big
I
thing
wouldn't put any of them on. I mean,
I wouldn't put the defendants on. They've got felony convictions, and they'll just get absolutely crushed by this prosecutor. But I would want to call somebody because before all this happened, the victim said that if I get killed, Drake did it. I would call somebody to say that, and if there's a video of that or whatever, I would call whatever it takes to get that in. It's not a great argument, but I that's the most compelling thing they have. A, you don't really know who's under the mask, and B, you know, the victim himself thought it was Drake.
right. No, I mean,
It doesn't cost you much. Like if the jury doesn't buy it, it doesn't make him dislike you anymore. So I would think that they would find a way to get that in.
Yeah, they should, but judging by the cross, I don't know if they can't impeach. Are they going to be able to get that in? I mean,
it's just the one. There's you got three shots at somebody with a confident idea on how to lay a foundation. Oh
wow! Yeah, that's that's crazy.
All right.
There. Oh, someone's head just popped up there, and
I don't know how long of a break do you take? An hour before you're done for the day?
That's what I was asked if there was a sidebar. This is.
They've been showing sidebars though.
Oh, have they? With the what do you call it? The white noise there. They put that sound over the thing. Over the speakers.
The judge doing the white noise was kind of cool.
Well, you can just read the.
Oh, that's interesting. The victim said the socials were hacked and he didn't write anything about Drake. Okay,
really?
So maybe that's not a good path to go down. I'm just saying.
Yeah.
I don't know what you have. The best thing they have is that their heads were covered during the commission of the actual crime.
Well, they did something right, huh?
So it's hard to say who it was, although we know damn well who it was. This guy was in the group. It's a group of 4 people. He knows all of them very well. He names this one. I can tell by his testimony. He wasn't mixing it up. He isn't confused who shot who, and it was all consistent with everything else. Is that going on right now? Someone put out a subpoena to Drake?
For deposition?
Because that would be kind of fun.
Well, they should have deposed him long ago. I'm going to ignore the trolls there. Washington Capitals.
Yesenia texted me today. She's like, there's going to be a deposition in some litigation involving Harry, like former Prince Harry.
Oh, uh-huh.
The Harry formerly known as Prince.
Yes.
See what I did there? See what I did? And
yes.
like, that is fantastic. There's gonna be some deposition. There's some I don't know, defamation case or some nonsense. I'm like, oh, that'd be fantastic because you know that's just gonna be just a mess.
Yeah,
but,
really. I mean, so that'd be great because that'll be
video
so they're going to depose Prince Harry. I mean, because all he does now is just whine about how he has no privacy, and all he does is do Oprah interviews and write books and go on book tours and gripe and moan about how no one will give him any privacy.
Do a Netflix special.
Yeah, you're breaking my heart, Harry.
where he's that's too bad. He used to be. I used to like him, like before this, but that's what happens. That's what happens if you allow yourself into the wrong hands.
Yeah.
It is his fault. All right, here we go.
Separate crimes that are felonies or crimes of dishonesty. Is that correct? Yes. I will ask you again. Earlier, just in my cross-examination, you said that you did not lie to the prosecutor in July of 2022. Is that correct? Yes. And then later in my cross-examination, you indicated that you did lie to the prosecutor in July of 2022. Correct? Yes. Which is a lie. Nothing further. Thank you.
Oh, nothing further.
Cross-exam on behalf of the jury.
I was going to say, isn't it true? You once said Miller Lite tastes great, and then you said it was less filling.
Did he say he's done?
He did. He's done.
So 12 separate felonies. You are really bad at committing crime.
I don't trust this guy anymore.
Objection, Judge. Argumentative and improper impeachment.
What's the question?
I'm objecting to
I'll
the
withdraw,
question.
Judge. I'll withdraw the question.
The jury will disregard the question. It's improper.
Let me get my
Oh yeah, somebody hook me up with Drake. He's welcome on to give his side. Trust me. If he wants to come on live, Mike will do it.
So I'm going to show you what was entered by the prosecution.
He'll sing his song and then copyright strike you, so you can't show it.
Is it Exhibit 9, the gun. This particular gun.
It's 9.
This particular gun that you testified to. You testified that this was Deidre Williams, my client's? Yes. Wasn't it your dad that got this gun for you guys? Yes. Yes, okay. And actually, your dad got all the weapons involved in this crime, correct? No. No? No.
At least this guy has more energy.
Weapons in this particular case that you've alleged did not come from your father?
Exactly what I was thinking.
I don't remember anymore. You don't remember which one, or you don't remember? What don't you remember? I'm sorry. I don't remember all the guns that you got. So how could you know that they all didn't come from your dad? That's my dad, and I don't know. So when you say you don't know, you're just saying you don't know, but you don't really know which one came from your dad or not. We can agree on that?
Wait, what was that question? You,
I'll withdraw the
you
question.
don't know. You don't know.
Can we agree that your
You
dad
don't know. What is
was
this?
a criminal?
Objection, Judge, relevance.
Was your dad in the business of not only selling guns, like you testified to, but of moving kilos of cocaine from Miami to Toronto? Isn't that true?
Judge, I'm gonna object and ask for a sidebar.
They might need more of a foundation to get that in. Well, it was
Everything
good
they,
while it lasted. And now we're back to the wall.
everything they do goes right back on them. That's the problem they have. So they want to beat this guy up and say, you're a criminal, your dad was a criminal, you're in a gang, all that stuff. Yeah, okay. And you're one of four in the frickin' minivan with him. So that's who you're hanging out with.
Right.
So it doesn't.
But his dad moves cocaine from Miami to Toronto, so therefore they're not guilty.
Therefore, he's not
it's a
credible.
lot. Yeah, so you might need to connect some dots there.
Yeah, and I just think, and when you come out with that, I don't know. I think this is pretty standard thought process. For cross-examination, I like as little as possible, and if I have a point, I want to go and punch it, and I don't want to water it down with bullshit side arguments. So I might, like, one or two things, just hammer it and get out so that the jury remembers it.
Yeah,
it depends in context on the witness in the case, of course, but
right. I know
that's
my clients. Yeah, your clients hate it. Because usually, like in the preliminary hearing, I get the person to admit the things that are good for us that I want them to say, to admit them under oath, and that's about it. And anymore, they're able to rehabilitate themselves or explain themselves, and you don't want
Sir,
that.
when was the first time that you met an individual
But
by the
clients
name of
hate
Travis
it. They want the long,
Savory?
beat up
You remember
the
meeting that
guy
individual?
kind of cross.
No. He actually goes by the name of Baka Not Nice. He's a Toronto rapper. Do you recall meeting him? No.
Not nice.
Actually,
Baka
isn't
Not
it true
Nice?
that individual, Baka Not Nice, is the individual that allowed for you to gain access to the video shoot of God's Plan in February of 2018 that was shot here in Miami? Isn't that the way that you got on the set that day? No. So your testimony to this court and to this jury is that you were never on the set of the God's Plan video filmed in Miami in 2018.
Do they have
Is that what you're saying?
footage of him there? That would be a good impeachment.
How much money in 2018 did you receive from either Drake or one of Drake's associates? I never met him. You never met Drake? No. Do you know who he is, though, right? Yes. Okay. But actually, in 2018, when this crime occurred, you didn't know who X was? No. Okay, so in 2018, you're from Broward County, correct? Yes. You listen to rap music, correct? Yes. And you're telling this jury that you didn't know
God's Plan is
literally probably the most
song by
famous
Drake.
rapper to ever come out of Broward County was in 2018, in June of 2018. That's your testimony? Yeah. You had no idea who he was?
Objection asked and
Yeah, hold on.
I didn't. But that's not surprising.
Now, you testified that you got rid of a phone previously, correct? Yes. Okay. And that phone, you've never been able to find it, you've never been able to help law enforcement locate it, is that correct? Yes. Isn't it true that the reason that you don't want that phone found is because of all the WhatsApp messages between yourself, people in Toronto, people that are involved in this case that you want to shield from, correct? I don't know the one in Toronto. Actually, you actually want to shield people from this case, like you just did with the individual in that car that picked you up. Isn't that true?
They're trying to implicate Drake. This is funny.
I don't identify her. Okay. Do you think, as a cooperating witness, that you have the right to come in here in front of a jury in a murder case and refuse to answer a question?
Objection argumented, Your Honor.
You had to wait for that ruling?
So you're
You didn't know what
testifying
you
that
had
that
to
person
do?
has nothing to do with Toronto, the person that picked you up?
Judge, I'm gonna object and ask for a sidebar with regard to this line of questioning.
You can answer.
Repeat that.
Is it your testimony in front of this jury that the individual that you're refusing to identify that picked you up in that car has nothing to do with Toronto?
Yeah, she don't have anything to do with Toronto.
Okay.
The real
Now,
winner here is the city of Toronto.
Actually,
People are
the
going to want to go
individual
visit.
that sold the gun that
Chamber
you
of
testified
Commerce
to were
is
involved
loving
in this crime,
this.
right? At least one of them, right?
Yeah.
Okay, you're that.
I thought we were doing a sidebar. No, we're not. But
And you,
No,
you
Judge
can't sit
overruled
here in front of the jury
the
and tell us
request.
how many of the weapons that were used in this crime came from him. Is that your testimony?
Yes.
Could we say at least 4 of them? Is that safe?
No.
Less?
Yes.
Okay, so you tell me that. You obviously have some recollection of how many. So I would like to ask you, help me, how many were involved? How many came from your dad?
I don't know the exact number.
Okay, so, but you know it wasn't 4?
Yes.
Okay, how do you know it wasn't 4?
Because I know for sure.
June, Daryl Brooks would have
Everyone knows
subpoenaed the
something
city of
going on.
Toronto to come and testify.
Okay, so 3?
I don't know.
Actually, the person that sold the weapons, a month after you finally cooperated in 2022, was murdered. Isn't that true?
What are you talking about?
Was your father murdered?
No.
Was your stepfather murdered?
K.L. Burke, you're in Toronto? You know Drake?
Now, you've actually
K.L., do you know this guy's dad?
given a version where you put my client as the person that's basically telling you what to do, correct?
Yeah.
But actually, in every single video and every single time that we see you, you're literally being chauffeured around by him. So I don't understand, like, how is it that you're saying that Mr. Williams, which basically looks like your chauffeur, is the one that's calling the shots? Is that what you're saying?
Objection, argumentative, and confusing and misleading question.
You can answer, sir.
I mean, I wouldn't say he's chauffeuring me around because it's actually his car.
Okay, but we'll get to that part because you're actually, the car that was used in this crime, you're the one that rented it, correct?
No.
You actually went physically to go get the car, correct?
Yes, I went with the person who went and got the car, yes.
Okay, so you actually physically went to go get the car, right?
Yes.
And you provided
Andrew,
at
that's a
least
better
now
safe word than your
at
old
least
one.
3 of the weapons involved,
Moor.
correct?
What are you talking about? I don't get what you're saying.
The weapons that were taken, you brought them, right? Your father gave them to you and you brought them.
I never told you that.
Oh, goodness.
Now, on the day that this occurred, when you went to Riva Sports, you testified that it was my client that noticed X. When in reality, wasn't it you the one that noticed him?
Leafs.
I can't notice him if I don't know.
No, I understand what you're saying. I'm just saying that wasn't it you the one that pointed him out, and wasn't it you the one that said, hey, that's X? Correct?
I didn't know that.
You actually went into the store with your phone, right? And when you're in the phone, in Riva, you pick up the phone and you call people to alert him of exactly who's in Riva. Isn't that true?
Yes, I called Michael Goldbright to let him know that he was in there, but the call never went through. But also, Diedrich showed us a picture of him before we went inside the store.
Actually, you called your dad. Isn't that true?
Negative. No.
Who was it that arranged, when you fled the state of Florida, who was it that arranged that? That was your dad, correct?
Yes.
Okay. And he arranged that so that you could flee, right? Flee prosecution.
So he arranged it so I can get myself together to see what I wanted to do.
get yourself together.
To see what I wanted to do, because he's actually the person that wanted me to turn myself in.
Okay, and what's the purpose of leaving the state of Florida if you want to turn yourself in?
I didn't want to turn myself in, but he wanted me to turn myself in.
You did it. You wanted to flee and escape justice, correct?
Yes.
Okay. Now, a lot of what you've testified to relies on your memory because you waited years and years and years pursuant to your testimony to finally come clean, correct?
Yes.
So this jury and all of us are relying on your memory. Can we agree on that?
Yes.
Okay. You're a drug addict. Isn't that true?
Judge, I'm gonna object relevance.
Judge,
Could affect his testimony. All right, sidebar. Wait, someone fill me in on on Drake. I know this guy said if I get killed, whatever, it was Drake, but they're not saying that Drake's the one that killed him, right? What are they? Like, how is Drake involved? Are they saying that Drake ordered the hit or what? Help a brother out here since Mike abandoned me. And yes, all you people in Toronto, the plural of leaf is leaves. I'm sorry. It's just the way it is. But it looks like I've helped Toronto Leaves fans identify themselves here in the chat. So he's lurking back there behind the scenes.
What the hell happened there? I was listening. Do we get a sidebar or another break?
Yeah, a sidebar. He asked the witness if he was a drug addict, and then they objected, and then it's a sidebar.
My God, this is a slow-moving trial. We did get through one of the defense attorneys.
So this is number two? This is two out of three?
This is number two. Number three I have the most hope for. But not a lot.
Uh-huh.
I'd say number three is the tallest midget here.
Yeah. At least he has, like I say, at least he has some kind of energy than that first one there was.
I think they all did an okay job in their opening statements. I really did.
Mm-hmm.
I think that cross-examination was brutal. It might have been as bad for the first witness, but I literally couldn't hear. At least I can hear now.
But okay, so Drake and this guy had a beef, but no one's accusing Drake. I mean, I guess what is the implication here, or that they're trying to connect to?
Well, I guess if
Drake that.
I guess supposedly, and I wouldn't know, and I'm not up on it, but I've heard that XXX said that if I die, it's Drake's fault. So if I'm a defense attorney, I'm trying to get that in. I don't believe that Drake had anything to do with it, but it adds to your burden of proof, reasonable doubt defense.
Right.
It does, no doubt about it. It not only like Drake specifically, but it just generally points like, hey, this guy had enemies. Some people didn't like him. It could have been a lot of people.
Right.
It kind of just gives you that whole avenue of argument at the end. So I would want to do it too, even though I don't believe it for one sec. I don't believe that Drake was involved. Although hell, I don't know. Maybe he was. I just.
But yeah, I saw someone in the chat say
you were in a relationship, correct?
Yes.
With Drake's money, he would be able to hire better hitmen.
Mercedes, and that's the person that you have tattooed on your forehead?
Yes.
Okay. And in addition to the relationship that you had with Mercedes, you had relationship with multiple other women.
Objection.
Is that true?
Relevance, Your Honor.
Judge, if I say, okay. Were you also in a relationship with Miss Tony Robbins?
Objection, relevance.
Ooh. You can answer.
No.
No. So you basically testified previously that you would call her every other day. Are you telling this jury that you would call her because it was a platonic relationship? You were friends? Is that what you're saying?
I don't know what platonic means.
Okay. Are you saying that you were not in a sexual relationship and that when you would call her every other day, it was because you guys were friends?
No, I was calling her every day.
Oh, good Lord.
Because we was renting cars to go rob people.
Mm-hmm. Were you doing that every day or every other day?
Every single day.
Okay, so your testimony now is that you were doing it every single day, correct?
Just about, yes.
Okay, and you're saying that every single day was through Tony, correct?
Yes.
All right. Actually,
through Tony, through Michael, through
you would think
Richard Williams.
Actually, isn't the truth that Mercedes would look through your phone and you would take every opportunity that you could to use Dietrich Williams' phone to talk to her so that you wouldn't get in trouble? Isn't that true?
Objection, relevance.
Ooh. You can answer.
No, it's not true because I had 4 cell phones that she didn't know about all of them. So I didn't need to use his phone.
Okay, I'm glad you mentioned that. You had
4 cell phones that she didn't
right?
know about?
Yes.
What's the need for 4 cell phones? What type of activity are you in that you need 4 cell phones? Can you explain that to this jury?
I do
4
fraud.
side chicks.
You do fraud.
Yes, I was doing fraud, yes.
Okay. And how do 4 cell phones help you do fraud? Please explain.
I mean, I need different phones to use.
No, I understand that you need different phones, but help me understand why you need 4 phones and how that can help you commit the crime of fraud.
For one, you changing the IP address.
I'm sorry, I didn't hear you.
For one, to keep the IP address changed.
Okay, the IP address for what reason? The IP
Take
address
notes,
for when
everybody.
you contact
Help
the
you be
person
better
that you're defrauding,
fraudsters.
No, I'm not calling anyone to defraud them. I don't want them to know that I'm defrauding them.
Okay, so is it by the internet? Explain it to me.
He just smoked you dopey
Explain it to
attorney.
me. Like, what is the IP address?
Hide my identity.
How do you use that for fraud? And how do you use the phones for that?
Objection.
Just blew up his cross. I can't believe we didn't anticipate that.
So even though you had 4 phones, the day that this occurred, you're telling the jury that you only had 1?
Yes.
And how is that?
Objection, argumentative.
You can answer. How is it that the day that you went to commit this crime is the day that you don't have your 4 phones, but you only have 1?
Because as you can see, I wasn't doing fraud anymore.
Okay, I'm sorry. You just testified that you were doing
We moved on from fraud to
and now
murder,
you're
okay?
testifying that you weren't doing
Wasn't
fraud.
doing
So
fraud
which is
anymore.
I wasn't doing fraud at the time because I was committing robberies.
okay, so you switched. You switched career paths. You went from fraud to robbery. Is that what you're saying?
I was going back and forth.
You had your feet in both pools, right?
Yes.
It's time for a promotion.
So the
Yeah.
day in June of 2018, on the day that this crime occurred, on that particular day, you had retired from fraud?
I wouldn't say that. I just didn't need the phone that day.
Okay. And the 1 phone that you had with you, that's the phone that you destroyed, correct?
Yes.
And you kind of touched on it in your prior testimony that you know that you didn't throw it away, right?
Yes.
But you can't remember what you did with it.
Yes.
Can you remember whether you destroyed the phone physically or you just tossed it?
No, I didn't destroy it. I don't remember destroying it.
You remember destroying it, but you can't recall what you actually did with it.
No.
Isn't it true that there's information and evidence on that phone that you do not want disclosed?
I mean, yes.
Right, and that's why you got rid of it, correct?
I didn't want to be attached to the phone. That would see me calling Michael Boatwright.
I'm sorry, I didn't hear what you said.
I said I didn't want to be attached to the phone numbers that would see me calling Michael Boatwright while we were in the store.
Right, or anybody else that you may have called before or after, including your dad, your sister, and a bunch of other people, correct?
The reason I destroyed the phone was because I didn't want anyone to know that I was calling Michael Boatwright.
Okay, but you actually used that phone to call your dad and your sister and all those people after the crime, right?
I called my dad.
You called your dad actually the same day, correct?
Yes.
So let's talk about that. On the day that this occurred in June of 2018, when was the first time that you called your dad from that phone?
Can't remember.
You actually called him while you were in Reba?
No.
When you say you can't remember at all, or was it an hour later?
It was after the murder.
Okay, but I understand that after the murder is a very broad term. I'm trying to limit it a little bit for the jury. Was it 4 hours? Was it 10 minutes?
Maybe about 4 hours, maybe. It was nighttime.
It was nighttime, okay. But you for sure remember that you did not call him from when you were inside Reba and you first saw him.
Objection asked and answered.
You can answer.
I don't think I called him on the. No, I didn't call him on the.
Now, the phone that you have admitted that you got rid of and that you can't find anymore, is it your testimony that that is the phone that you had at Reba on the day that this occurred?
Yes.
Okay. And do you know whether or not you called your sister from that phone?
Yes.
Okay. And you took that phone up to Georgia?
No.
Okay. Where was it that you destroyed that phone or got rid of that phone? What state were you in?
Florida.
Florida. Were you at home?
I don't remember.
Okay. Do you recall the location that you were in when you got rid of the phone that you took to commit this murder?
No.
Now, you would agree with me that that is a fact that should ring in your memory. That's an important fact. Do you agree with me?
Objection argumentative.
Sustained.
So you're testifying in this case because you want to save your own skin, or do you genuinely have remorse?
Objection not relevant.
Oh.
Which is it, sir?
Can you repeat that?
Are you testifying in this case because you want to save your own skin, or do you have genuine remorse?
Well, I definitely would like to get.
They're not mutually exclusive.
But I definitely have remorse. He's
It's a false
I sit
dichotomy.
and look at the stand and see people crying, and I'm trying to do my best to get family and friends and his fans justice.
Okay. So you have remorse today, now, when you see them, or you had remorse previously? When did this start?
I've been having remorse.
It was
about 5 months, 6 months.
You have a good answer.
5 months or 6 months. So really consistent when the time that you finally came forward allegedly and told the state attorney the truth. Is that what you're testifying to?
Objection argumentative.
I'll give you some attitude.
You can answer, sir.
Well, actually, I had a lot of time to think about it because I don't know if I should say it or not, but I'm on 23-hour lockdown, so I have a lot of time to think about it. I'm thinking about other people.
Okay.
Instead of being selfish, let me think about myself and trying to just.
But you actually had years and years to think about that, and then coincidentally, you just started thinking about that when you finally cooperated with the state of Florida. Is that right?
I mean, I wouldn't say I didn't have no remorse at all, but by me sitting and looking in the stands, I know I'm doing the right thing. There's a lot of people that was hurt by that.
But you're really sitting on the stand because you want to save your own skin and your own life. Is that correct?
Of course, I would like a lighter sentence, but I want to do the right thing.
Now there was a picture that was entered into evidence of you on the day of that you were arrested, your mugshot. Do you recall that?
Which mugshot?
Your mugshot.
Which one?
I mean, the one that they published to the jury. Here,
I got arrested July 25th. I was in Dodge County. I had a mugshot then.
Okay. I'm talking about the mugshot that was published of you that the jury saw.
Sidebar. Sidebar. Take a drink, everybody.
Right here, the judge is saying, I don't care what happens here. It's not going to interfere with my fishing. You better wrap this shit up.
You got half an hour. The clock is ticking.
Okay, Drake is coming to court on the 24th. This trial has no business going to the 24th, but I believe it will.
Well, yeah, I just saw the that link that.
And I have my doubts about that. Not that someone didn't publish that, but I just have my doubts that Drake can't weasel out of this somehow.
Yeah.
I wouldn't want him giving any statements on this, even though he probably didn't do anything or was any related. It's just you just don't want to get pulled in and
right.
You just want to get tarnished by it.
So yeah, it looks like the order from what I'm reading here. Yeah, he shall appear for deposition Friday, February 24th. So 2 weeks from today, he is.
So he's going to appear for a deposition 2 weeks from today.
Yes, he must appear before this court on Monday for a
Maybe
deposition on Friday the 24th, and appear. He must appear before this court on Monday, February 27th at 10 a.m. Eastern time, so the court can determine why he should not be held. Oh, he'll have a contempt hearing, a show cause, or whatever, if he doesn't come to court on Friday the 24th. He'll have a show cause hearing on Monday.
I don't know how they do that, though. How do they compel that? They can't enforce this order. I mean, I don't know anything about Drake, but I'm seeing here he's Canadian. Okay, he's in Canada. What, you issue a Florida subpoena to frickin' Canada? Pound sand.
He's probably here in the U.S., though. I mean, I don't know how much time he spends in.
Yeah, if you get him in the U.S., maybe. But that's a nightmare in and of itself.
Yeah.
He'll probably have attorneys come in and get the subpoena quashed for something like we just discussed, and that'll be that.
Yeah, I mean, I don't know what. Yeah, he can afford to hire attorneys that should probably be able to get him out of this.
Hell
or
yes,
just
the
testify
guy's
like,
busy. He's got money.
I don't know. Yeah, I didn't like the guy, but I'm sure he's got an alibi as to where he was when the murder happened, and there's nothing.
Well, that would just be a loss for Drake, assuming he didn't do anything, which I have no idea if he did or didn't. But assuming he had nothing, which is my best guess that he did nothing related to this, he just doesn't. He doesn't even want a public record that he was forced to testify at this shit show. Yeah, you know.
Yeah. Well,
if I'm Drake,
yeah, I mean,
I'm calling in an attorney saying, quash this subpoena for me. Get this thing out of my way. I don't want to deal with it.
Yeah. Now we don't even have a wall or a ceiling. What happened?
They might have just ducked out on us at this point.
Yeah. We need Kim Blandino here to tell us that a drake is also a male duck. To share drop some random knowledge on us. Or the Seinfeld reference, I hate the Drake. I hate the Drake. How do you hate the Drake? I love the Drake. Anyway.
I missed the wall. All right, I know. It's not quite the same without the wall. I don't know. Both of those guys, although he's getting through his cross. At least he's not going point by point on lies.
But I mean, what
Yeah.
Well, they have to prove. I mean, okay, so they get Drake to come, and I mean, you know what Drake's going to say is, yeah, I mean, worst case, he said, yeah, I didn't like this guy. He stole my things, or he accused me of stealing, or whatever it was, his music or
I
some
think
of
they
his
probably don't
whatever.
want him.
But I don't, I was in wherever.
I think the defense strategy is get somebody in to get somebody in to say that he made that statement or show a video.
Mm-hmm.
Then subpoena Drake, have him blow it off because they really can't compel his testimony.
Right.
And then be happy with that, because you don't really want Drake showing up and go, hell no, I was in friggin'
Right.
Asia at the time, and
On my
I have
tour,
nothing to do
right.
with it. In fact, I wanted to work with him and destroy your little red herring that you've created.
Right. What's he going to say? Yes, I did. I would never hire these guys to carry out the murder that I wanted. I got better people, and they're so good that we pinned the blame on these chumps. So, suckers! I mean, is that what they expect him to come and testify to?
Yeah, that's the other one, is that Drake ordered the hit, but that doesn't help them, because if you're saying Drake, if you're saying Drake hired somebody, it doesn't.
I mean,
it doesn't get you out of it,
right?
Then he
Yeah.
said, "Yeah, fine,
I paid them
you."
$15,000 to kill this guy. I gave X $50,000 and told these guys, hey, if you go kill him, you can have all that cash, but only give $5,000 to the to the other guy. I mean, yeah, I don't know. Plus, Drake's Canadian. Canadians have a reputation for being nice. He could go on that too. Like, we're too nice. We don't kill anybody. No, I will say there was, yes, the one Canadian that are not nice are Canadian geese. Canadian geese are terrible. They're awful.
Oh, they're cranky as hell.
Yeah. No, they're scary too. They're aggressive.
All right, what are we doing here?
So you call, right? And that's when the car that the jury has seen rolls up and your reinforcements arrive. The people that actually assisted you in committing this crime.
That's the question you're saying. Is that what happened?
No, I'm asking you.
No.
Okay, I understand. I understand what you're saying. And then after this crime is committed, right? That's when you call your father and you tell him it's done. Is that what happened?
Objection, hearsay, improper, no basis, good faith basis for this question.
Counsel.
Sidebar.
Ready from trying to testify.
Come on, do it. Sidebar.
Now, you've claimed previously and refused to testify regarding the identity of the person that picked you up after that accident. Now, just to be clear, my client wasn't part of that accident, correct? Deidre Williams was not in the car when that accident occurred, right?
No.
Okay. And your fear of that person, is that a fear that you're going to be killed?
Sure you want me to answer that question?
No, I'm just asking you, is the fear to the point that you want to be killed?
I don't think that question is appropriate for the jury to hear.
Okay, well, listen, you're the one that's sitting here
You
refusing
get to decide what questions are appropriate. The
in a
judge
murder
doesn't
trial in front of
say
a
that.
jury. So are you under protective custody?
Yes, my status is protected custody.
Okay, so you're under protective custody, and even with that status, you're that fearful of this individual or the powers that be regarding that individual that you come here and refuse to testify.
Yes, they're gang members.
Oh, you done stepped in it.
What is it? They're gang members?
Is that what you wanted?
Well, there's another kind of banging there. They're gang banging. Oh, back to the wall.
Well, we all know it's true. It was such a stupid thing to go, you're so fearful. Yeah, first of all, I'll tell you what testimony did get in. What testimony got in is that one of the defendants threatened me yesterday. And we had a big sidebar about it, and it got in.
Yeah, because they killed this guy named Triple X. Maybe I don't know if you've heard. So yeah, I'm scared.
And you don't have to know much about gangs or crime generally to think, yeah, this guy's in danger.
Yeah. Well, he's not going to survive in prison. I mean,
yeah,
he's not.
Well, will they separate him?
I mean, they better.
But isn't that true of almost everybody who's in prison at some? I guess not if you're not there.
No, I mean, no. Seriously, the pedophiles and snitches are the ones that really have legitimate fear. I mean, yeah, certainly you can offend someone or do anything, but
yeah, everybody.
No, like I mean, guys, everyone. I mean, wants their paperwork basically to show. It's like like we described it as like your passport. It's like hey, no. I just robbed people at gunpoint. I just
right.
I just robbed a 7-Eleven. I didn't. I got standards. I would never snitch or I would never hurt a child. So I mean, it's a real thing.
Oh my God, that's weird. After like just a rough day of like bad cross-examination, this thing just blows up right at the very end. Did he say, I don't think that's appropriate for the jury to hear? Did the witness say that?
Yeah, he did. That's what I'm like,
okay, so the witness is effectively objecting to the question.
He's the judge. It's like, wait, when did you get to be judge?
Right,
Sorry,
right.
yes, that's not appropriate for the jury to hear. The jury's going to disregard that. It's like, come on.
But then I think you went. The problem he's got right now is they're saying, this motion, like they talked about this gang activity and all this stuff.
Right.
The problem is he didn't explicitly ask him about gang activity, but it was a responsive answer to his question.
Mm-hmm.
They can't strike it. The jury just saw it. It was the only interesting thing of the day.
Wait, you're telling me, syndicate leader, are you in Canada and you call Canadian geese Cobra chicken? Okay, we need more details on that. And if you're in Canada, wouldn't you call a Canadian goose just a goose? See, S. Cottrell there. Hate Canadian geese. I got attacked. I'm telling you.
No, it wasn't. They wanted to put him in they wanted to put the witness in a gang, but not all their clients. This guy said we're all in a gang, man. Which is obvious anyway.
Well, but now if you're one of the co-defendant's attorney, would you like I'm going to move for a mistrial because that's unfairly prejudicial.
Maybe they were angling for mistrial.
Because he's whatever, outed them as gang members. And we got them as I don't know.
Yep, that might be an angle for a mistrial. Good point.
I would at least make the motion. Wouldn't hurt. You would preserve the issue on appeal. But although I wouldn't. No, but I mean that's the other attorney, I mean, so yeah, I mean your co-defendant's attorney does that, brings that out that these guys are gang members, then yeah, you've. I mean, I don't think the attorney that was doing the cross, I don't think he really has a leg to stand on for declaring a mistrial because he opened the door for it. But I think the other ones at least should make the motion.
Yeah, I don't know if he opened the door in the sense like he didn't say, are you all affiliated with the gang? Then you've opened the door, but then you've explicitly asked about gang activity. Fine,
right.
But
he's asking. Well, I mean, a lot of questioning was
pressed hard on a question where that response is not out of line. It's responsive. And it just gets down to what instructions was he given as a witness with regard to that prior, which I don't know because that would have happened before the trial,
right?
Or
yeah, I mean, I don't know. Yeah, they have motions eliminated and not mention gang affiliation or.
Mm-hmm. Oh, they were because they were arguing about it. So there's some sort of motion eliminate involved.
As if taking pictures with
As if it
And
isn't obvious.
$100 bills is not.
Yeah. Yeah.
I mean, just seeing that
flashing
is
gang signs,
with
rolling
your
around in a friggin' minivan with 4 other dudes, wearing those ridiculous outfits. A lot of people could connect those dots without explicitly hearing it on the stand.
yeah, you think?
Well, there we go. At least we had a little excitement today.
Yeah,
After a long trudge, we had a nice
had some
blow up.
gangbang in there. Yeah.
Boom. We had a full dramatic hamster. I don't know how I did it. Thanks for coming by, buddy. I don't know how I lasted this long on seltzer water.
Yeah, I don't know, man. Thanks for having me
Yeah,
on. I don't know what we got.
I'm saving my cocktails for my happy hour.
Oh yeah.
Oh yeah.
We'll save it for my premiere today, 3:30 Pacific, 6:30 Eastern.
Oh, if I can get going, maybe
Las Vegas.
maybe I'll redirect my happy hour into your premiere.
There you go.
How's that?
That sounds like a great idea. That sounds like a fantastic idea.
Just crazy enough to work? We'll see.
Just crazy enough to work.
We'll see if I can pull off the technological miracle.
Well, hopefully you're not drinking White Claws, so you should be able to.
Yeah, I better I better set up that redirect before the stream starts. Otherwise, the couple cocktails in, it may not happen.
Yeah. Well, you'll see. She's a charming young lady here that we're gonna check out her body language and oh my goodness.
We're gonna check out her
charming
body language.
Lady. Check out her body language. Yeah, you know what I mean.
Hey.
I don't know what I'm talking about. Yeah. Oh, dear.
Oh.
Ben is a member of the Law Talk with Mike gang. Oh. Uh-oh. I don't remember signing up for the I didn't get my membership card to the Law Talk with Mike gang.
You don't have to
you don't talk
consent.
about it? Oh yeah.
It's all against your will, Ben. It doesn't really matter. You don't get to agree or disagree.
Yes, Maria, tune in and you will see her body language. Yeah, I mean, I learned about micro expressions, things like that. I'm telling you.
Mm-hmm.
Oh yeah,
I got your micro expressions right here.
Uh-huh. Debbie, what is that? Real love or chemical love?
Well, I'm glad to see we didn't run Kel Marie off by asking her about moistness.
Oh yeah. Kel Marie is axing for the gang sign. Yeah, see, I don't know. I didn't through orientation. I didn't get any of that in the gang orientation.
We don't have one.
And then I didn't get invited to the end of the year banquet. Like, what kind of gang is this, dude?
I think this might be.
I don't have my membership card.
Right
I didn't get my gang signs in orientation. I wasn't invited to the end of the year banquet. The hell kind of gang are you running, man?
All
Skeptical chemist, are we starting? No, we're not starting a gang because all those things I just listed.
All right, ladies and gentlemen of the jury, first of all, I want you to disregard the last question and answer. And if you recall, when we started, I told you from time to time, you might hear something that I will tell you to disregard. It requires some discipline, but
yeah, know about the gang affiliation? Just forget about that.
Things should not play a role in your
perfect. You just unring that bell.
I want to first that you understand.
Don't think of the word gang.
Regardless of
think of the word moist.
Question
anything else
that I told you to disregard, that there is no evidence before this court
It was that DTG
that
Ixnay on the Angigay.
or Mr. Newsom are in any way involved with any gangs or anything along that line.
Oh, good Lord.
Mistrial.
Concerns in that
You're
area,
absolutely right. That's
any kinds of thoughts.
That's what
motion
they're
for
talking
mistrial.
about.
It's the first basis for appeal on this conviction, which is inevitable.
It's not there. It's not there for your consideration.
It's not there. Don't believe your lying eyes and your lying ears.
We don't want any questions that have been disallowed to in any way open up any lines of inquiry or thought that are just not there and not proper.
Sure, yeah, keep talking about it. Yeah, that'll help de-emphasize the gang.
This is a joint trial.
Asking them to stop talking about it, don't think about it, and completely disregard it. Yeah, that I mean, I know they have to do it, but it obviously.
Each witness and go through this over and over again, but you are to consider the evidence that's adduced at trial.
You know, sometimes on these things, I almost think it's just better just to just to ignore it.
And your verdict.
I don't know. I mean, what do you think? Because now it's like, oh, he said they're in the gang, and now I can't think about them being in a gang, but they're doing a lot of, making a big deal about me forgetting about the gang affiliation. Oh, see, Giselle, you are an ideal juror then. You already forgot that they're in a gang. Good job, Giselle. She's already thinking of the word moist. Am I right, Kel Marie? It just looks miserable there. How many people there? Was it 1, 2, 3, 4, 5, 6, 8 people on a big long table?
No further questions, Judge.
All right, thank you.
Oh, sorry.
Well, 5-5. All right. All right, so we are going to break for the weekend. As with each time we break, I will remind you, you're not formed any definite and fixed opinions, merits the case. You hear all the evidence, arguments, counsel, instructions, and law by me. Until that time, you must not discuss this case, even among yourselves. During the course of the trial, the court will take regular recesses, during which you're permitted to separate and go about your personal affairs. During these recesses, you shall not.
And forget about the gangs.
Permit anyone to say anything to you in your presence, and if it does, remind them.
Don't even think about it.
Leave them.
Don't even think about it.
If you see counsel, witnesses, defendants, anyone else associated with the case in the hallway, they will ignore you. They are not being rude. They are following the orders of the court. Please insulate yourself from any exposure to media, press, gossip, or other stories that may be out there. And with that, it's Friday. That's good. We got a couple of days off. Monday morning, 10:30. In the reception area again.
Well, there you have it, brother.
How about that?
So you know there was a motion for mistrial made.
I'm sure they're probably waiting at least for the
right there, and he said
well,
no, and then he thinks okay.
Well, they would have to put it on the record, so they're probably waiting to excuse the jury, and then they'll probably make the motion because they would need to make the motion on the record, not at a.
They might do that. That won't be very exciting. It'll be denied, and then we'll go forward. Judge is going fishing. They're starting up 10:30 on Monday. I don't.
Yeah, Judge is going fishing. He's ready for his Super Bowl party on Sunday. He's had enough.
He's had enough. So I will probably follow that one a little, but I probably won't do it like I did this week. We did the whole first week, but we got fireworks at the end.
Yeah, it's exciting.
Very exciting. Very exciting. Fireworks with top-notch legal commentary from Ben Bateman.
Yes. Oh, right. Can't get this anyplace else, right?
All right.
Oh,
All
dear.
right. This stream, I'm gonna end this. Thanks everybody for coming out. This stream is going to redirect to Biggin, who I think is starting right now. And then when I do, and then I'm starting my happy hour at 4:30, and that will redirect back to Ben.
I like
It's
it.
very, very exciting. Very,
Yes.
very exciting Friday party. We did the hard part. We did the trial. Now it's time to party, people.
Yes.
We're gonna learn about body language. We're gonna have a cocktail.
Does she like you? How can you tell?
There you go.
Watch and learn.
All right, brother. See ya.